Morning.
Lord, with the consent of the other side, I beg to mention item number 29.
There is a judgment. Let
I'm
me
sorry,
first
madam.
pronounce the judgment. Mr. Lalpakjwala, Ms. Valentina, can you hear me?
Yes,
my lord.
I am just reading the operating part of the judgment. In the present case, the SDCC Aizol issued the impugned heirship certificate without any evidence whatsoever. Further, the said certificate was issued before the expiry of the notice period, depriving the appellant opportunity of being heard, which amounts to total infringement of his potential statutory right over the subject land guaranteed to him by the Constitution of India. The first appellate court, by upholding the said heirship certificate, has therefore committed gross illegality. Therefore, the decision of the SDCC Aizol and the first appellate court are based on no evidence and perverse, and have also committed gross illegality in arriving at the impugned findings. As such, the said decisions are palpably erroneous and contrary to the settled position of law and liable to be reversed. Accordingly, the first substantial question of law is answered in favor of the appellant / defendant number 1. Similarly, the second substantial question of law is also decided in favor of the appellant. In view of the above, the judgment and order dated 13/3/2023 passed by the Court of Additional District Judge Aizol Judicial District in RFA number 30 of 2019, arising out of heirship certificate number 564 of 2002, shall be set aside and quashed to the extent that it has declined to interfere and set aside the impugned order dated 2/12/2002 and connected heirship certificate number 564/2022 issued by the SDC Aizol. Consequently, the order dated 2/12/2002 stands reversed, and connected heirship certificate number 564/2002 issued by the SDC so-and-so stands set aside and quashed. Resultantly, the matter relating to issue of heirship certificate number 564 of 2002 in respect of LSE number 770 of 1984 and LSE number 771 of 1984 is remanded back to the court of Mr. Lalpakjwala, please hear this out. Is remanded back to the Court of Civil Judge, Junior Division, Aizol, correct? For deciding matter afresh by giving due opportunity to the appellant in accordance with law. Accordingly, appeal stands allowed. Send back LCR.
Follow.
It's remanded back to the Court of Civil Judge, Junior Division. That is the court, correct, for deciding the heirship certificate now? Earlier it was SDCC, but I think it has been changed now. Is it correct, Ms. Valentina, Mr. Lalpakjwala?
It's correct.
I cannot hear you all.
It's
It's
correct.
correct.
All right. You should be getting the order by end of the day.
Deeply obliged.
Yes.
With the consent of the other side, my lord, I beg to mention item number 29, my lord. It's a contempt matter. I am for the respondent. We need
Mr.
4
Singh,
weeks.
item number?
29, my lord. We need 4 weeks time to file our counter, my lord.
29 is the order matter, Mr. Singh. Please do not make any mention of order matters in this court. Please wait for your turn. This court shall accommodate.
May I please, Lordship?
Yes.
Item number 48, my lord. I have filed an application for amendment of the writ petition, my lord. That may be allowed to be brought on record. In view of the implement of the new respondents, my lord.
You want that to be called?
Yes, my lord. My lordship.
In item 40?
48, my lord.
May it please your Lordship. Lordship, I beg to mention item number 23, Lordship. In this case, I am for the respondent number 7 and 8, Lordship. My senior is out of station. Kindly accommodate for the day, Lordship.
You are for?
Respondent number 7 and 8, Lordship.
It is submitted by Mr.
P. Bordeloi,
P.
Lordship.
Bordeloi, that Mr. P.J. Soikia,
Lordship.
learned senior counsel, appearing on behalf of respondent number 7 and 8 is out of station and accordingly seeks accommodation in the matter. Stop.
Lordship.
Prayer is not opposed. List this matter
After vacation.
after 2 weeks on a date to be fixed by the registry.
Oblige, Your Lordship.
Wait, please, Your Lordship. I beg to mention item 30. It's a contempt. I'm on behalf of respondents.
30.
Lordship, 30.
30. Yes.
Some instructions are forthcoming. Lordship may give us 2 weeks.
Have you taken consent from the other
Consent
side?
has been taken.
As prayed for by Mr. I. Borthakur, learned counsel for the respondent, comma, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Oblige.
Lordship, some personal difficulty on my part. I would like to mention item number 31. I have taken consent of the other side, Lordship.
You have
31.
as prayed for by Mr. S.R. Borwa, learned counsel for the respondent number 1, comma, which is not opposed by the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
May I please, Your Lordship? I beg to mention item number 20, my lord. The matter become infructuous, my lord. Matter was regarding eviction, my lord. Now they have approached to the civil court, my lord.
All right. Your name?
S. Hazarika, my lord.
Heard Mr. S. Hajorika, learned counsel for the petitioner, stop. Also heard
NF Relay, my lord. SK Medhi, my lord.
Mr. S.K. Medhi, learned DYSGI for the respondent. Stop. Mr. S. Hajorika, learned counsel for the petitioner, submits that the writ petition in the meantime has become infructuous. Stop. In view of the aforesaid endorsement, this writ petition stands dismissed for being infructuous.
I'm deeply obliged.
Disposed
May-
of.
May I please your Lordship? Lordship, with due consent from other side, item number 37 may kindly be passed over for the day, Lordship.
37.
Lordship, I am not well, Lordship. I am suffering from fever, Lordship.
As submitted by Mr. R. Das,
RM Das.
RM Das, learned standing counsel,
Lordship.
Water Resources Department, comma, which is not opposed by the other side, list this matter.
After which,
Give a date in first week of August.
Lordship,
List this matter again for hearing on such and such date.
8 deeply.
Please, Your Lordship. With the consent of the other side, I would like to mention item number 14.
Item number?
14.
Yes.
We would like to file our affidavit, so kindly some time may be granted.
You have taken consent of the other side?
Yes, my lord.
As prayed for by Mr.
As Banikya on behalf of NDECA.
As prayed for
As Banikya on behalf of Mr. NDEC.
by Mr. S.
Banikya.
Banikya, learned counsel on behalf of Mr. N.
NDECA.
And DECA, learned standing counsel APDCL, comma, which is not opposed by the other side, list this matter after 3 weeks on a date to be fixed by the registry.
May I please, Your Lordship? I beg to mention item number 41, Lordship. This matter become infructuous, Lordship.
41.
1.
In item 41. Heard Mr.
M. Hussain on
N.
behalf
Hussain,
of R.
learned
Ali.
counsel, appearing on behalf of Mr. R. Ali for the petitioner. Stop. Also heard Mr. S. Borwa, learned government advocate for the state respondent, and Mr. B. Gogoi, learned standing counsel, finance. Stop. Mr. So and so, learned counsel for the petitioner, submits that the matter in the that this writ petition in the meantime has become infructuous. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, this writ petition stands dismissed for being infructuous. Disposed of.
May I please, Your Lordship? I beg to mention item number 19, Lordship. Matter, Lordship, petitioner want to withdraw this matter.
Your name, please.
A. Gogoi, Lordship.
Heard M.S.A. Gogoi, learned counsel for the petitioner. Stop. Also heard Mr. S.S. Roy, learned government counsel for the state respondent. Stop. Next param, M.S.A. Gogoi, learned counsel for the petitioner, submits that she has received instructions from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. Stop. Prayer allowed. Writ petition stand dismissed for on being withdrawal. Okay? Yes.
May it please, Lordship, with the consent of the other side, I beg to mention item 13 of today's evening. Lordship, the matter
19
become
disposed of the Rupak. Yes, item 13.
13. Lord.
Yes, what do you
Matter
want?
is- Matter has become infructuous, my lord.
Infructuous. Your name?
D. Boran.
Heard Mr.
D. Boran.
D. Bora,
Right.
learned counsel for the petitioner.
My lord,
My senior's name may be
D. Bora on behalf of Mr.
M.K. Chaudhary.
M.K. Chaudhary, learned senior counsel for the petitioner. Stop. Also heard
Lordship 6 to 8. M Das.
Mr. M. Das, learned counsel for respondent number 6 to 8, and Mr. N. Goswami, learned government advocate for the state respondent. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that the matter that this petition in the meantime has become infructuous. Stop. In view of the aforesaid endorsement made by the learned counsel for the petitioner, comma, this writ petition stands dismissed for being infructuous. Disposed of.
May it please, Your Lordship. With respect to item number 9, the matter has become infructuous, Your Lordship.
Infructuous?
Yes, Your Lordship.
Heard, Mr.
Lordship, I'm mentioning on behalf of
Your
BD
name?
Das, HR Das.
HR.
HR Das.
Mr. H.R. Das.
On behalf of Mr. BD Das.
On behalf of Mr. B.D. Das, learned senior counsel for the petitioner. Stop. Also heard Mr. P. Sharma, learned standing counsel, AFDC, and Mr. Goswami or Borua, and Mr. S. Borua for learned government advocate for the state respondent. Stop. Mr. Das, learned counsel for the petitioner, submits that this matter in the meantime has become infructuous. Stop. In view of the aforesaid endorsement, this writ petition stands dismissed for being infructuous. Disposed of.
Lordship, with the consent of the other side, I'd like to mention item number 7, Lordship. There are discussions going on with regard to amicable settlement, Lordship. Kindly just...
You are for the petitioner?
Lordship.
Your name?
D. Mohanto.
MSP Mohanto, D. Mohanto, learned counsel for the petitioner, submits that out of settlement process is going on in the instant matter, and accordingly seeks some accommodation to facilitate the said process. Stop.
Sure.
Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Much
Yes,
obliged.
call the list, please.
Hearing. Item number 46.
My Lord, in the last occasion, Lordship was pleased to call for scan copy, my Lord. As per office note, my Lord, 24/6, my Lord.
Mr. Sharma, the difficulty is that the petitioner is not here.
My Lord. Scan copy also not received.
Not received.
Not received, my Lord.
You please inform him then.
My Lord.
Await for the scanned copy of the LCR from the courts of Session Judge Lakhimpur. Stop. Let a reminder be sent.
My Lord.
List again on.
After vacation,
Give a date.
my Lord. 22nd, my Lord.
Please inform him, Mr. Sharma.
My Lord. I will tell you. Obliged.
Item number 1.
May it please, Your Lordship.
Yes.
Lordship, affidavit in opposition has been filed, my Lord, by the other side, my Lord. We will need some time to seek instruction from
All right. M. Bora?
B. Bora.
B. Bora. Your name is here?
Lordship, maybe on behalf of Ikibnia.
MS B. Bora, learned counsel for the petitioner. Learned counsel for the petitioner seeks some time to take opportunity some time seek some time to obtain instruction as regards the affidavit in opposition filed by the respondent number 1 on 11/4/2024. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
I'm on.
Item number 2.
My Lordship. Lordship, this is an insurance matter. So my claim is denied merely on the prescription where it is stated that I was suffering from cancer. So that is, Lordship, denial only on the basis of a prescription. This is not a medical investigation report.
Because the factum that you were suffering from cancer was not disclosed at the time of executing the insurance.
That is the allegations of the respondent.
On that ground it has been correct.
Yes.
But that is their policy. Now how will this writ court go into it? Yes, what had happened thereafter?
Lordship,
What are you challenging here? Insurance company has filed your, have you filed your affidavit?
My lord, I am not for the insurance, I am for the hospital 4 and 5. Our diagnosis was a sale, but we had given that finding on the basis of the information given by the patient at that time. So that information came up in his report.
So what is actually under challenge in this petition?
Well, this is in 10 to 2020.
What is this impugned order of penalty dated 10 to 20?
Well, that is not actually an order of penalty, I believe. That is his rejection. Placed before his exam, decided to uphold the repudiation of his claim. Decision of the divisional office.
Who has passed this order?
This is the senior divisional manager, but he has only
of the insurance company.
Insurance company.
So where are they? Who is representing the insurance company?
The LIC. It has to be the LIC.
So who is appearing for them? Respondent number?
2 and 3.
Mr. Bhumik, I think, appears. They are not here.
They are not.
Lordships, I have got the service copy from the respondent number 2 and 3, but not the service copy from the respondent number 4. I need the service copy.
Affidavit in opposition?
Yes.
You have not been given?
Not yet supplied.
No, but where is the counsel? Unless the counsel is here, how can this court... Anyway, you are Mr. Kalita?
Yes, sir.
Heard Mr. P. Kalita, learned counsel for the petitioner. Also heard Mr.
N. Barwa.
N. Barwa, learned counsel for respondent number?
4 and 5.
4 and 5. Stop. Mr. Kalita submits that though he has received the affidavit in opposition filed on behalf of?
2 and 3.
2 and 3.
But not.
However, he has not received the affidavit in opposition filed
4.
On behalf of respondent number 4. Stop. You give him a copy.
4 and 5. I have the copies.
Mr.
4 and 5.
Barwa is Mr. Barwa is in the mean. However, there is no representation on behalf of respondent number
2 and 3. 2 and 3.
2 and 3 is you?
Well, I'm 4 and 5.
Oh, on behalf of respondent number 2 and 3. Stop. List this matter on after 2 weeks on a date to be fixed by the registry. Stop. In the meantime, let the affidavit in opposition filed on behalf of respondent number 4 be served on the petitioner. Stop.
4 and 5.
4 and 5.
Lordship.
My lord, the matter of my lord against the guarantee, judgment of guarantee. But my lord, I have not in contact with the client for last 4-5 years. So whether bank has already attached the shop and they have taken the possession, whether that has been executed.
You are Mr. Nath?
Yes, ma'am.
Mr. S. Nath submits that since this matter has been listed after almost 3 years, he may be allowed some time to obtain instruction from the petitioner as whether anything is still surviving in the writ petition. Stop.
May I please, Your Lordship? Your Lordship, basically in this writ petition, a challenge has been made to the judgment of the Debts Recovery Tribunal, which is an appealable order.
That's what he said. Let him obtain the instruction.
Yes.
List this matter, prayer allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Okay. May it please, Lordship. Lordship, this is a case, Lordship. The petitioner is a power of attorney holder of the original owner of a plot of land, Lordship. Their lands were, Lordship, occupied by some Salfa members, Lordship. So
Salfa members.
So they prayed for eviction of those Salva members to the Deputy Commissioner and respondent authorities, Lordship. They have taken initiative and thereafter an order was passed, Annexure G, page 31. I have been newly engaged in this matter, but Lordship, from the affidavit in opposition, I have seen they have not properly filed the affidavit in opposition.
Who is the concerned authority who is going to file the
Deputy
affidavit?
Commissioner, Lordship.
Mr. Borua, you have a copy of the affidavit?
Additional Superintendent of Police has filed an
Additional
affidavit.
Superintendent has filed.
So
But Deputy Commissioner
Is it
has not
sufficient?
Yes,
Or
that is
do you
sufficient.
want to, because from the petitioner side they are saying that it is not sufficient.
No, it is very much sufficient. It is made it very clear. Only 2 paragraphs are very apparent here.
Before that, Your Lordship, kindly see Annexure G, page 31.
1 second, which is those 2 paragraphs?
4 and paragraph 6.
Who is Roosevelt Rabha?
He is the Salva member, Lordship.
So the land is already transferred in his name.
How it was transferred, Lordship? It's a Miyadi Patta land. It is an admitted fact, Lordship.
No, but that matter has to go to the civil court.
That's
No, Lordship.
Further, it has
is-
come to the knowledge of the undersigned that pertaining
Civil
to the
suit
land
is
in question,
pending.
one civil suit is pending.
No, Lordship, before that, Your Lordship, kindly see Annexure G, Lordship. Already an initiation was taken by the government for shifting of those persons, Lordship. They are reluctant for shifting, Lordship.
You see, be whatever, but it appears that a suit is pending,
Lordship.
and it appears on record. It has already been correctly wrong or
Rightly or wrongly.
wrongly, rightly. This court doesn't know, but that matter is now pending before the civil court.
No,
Then
Lordship.
how will this
Who
court
has
grant
filed,
you
who
any
has
relief?
filed that civil suit? There was nothing on record, Lordship.
The affidavit is there. The government's affidavit on oath is there.
Lordship,
This
may-
court cannot ignore
No.
the averments made on oath by the state government.
For that only I am praying Your Lordship may direct them to furnish the documents,
No,
Lordship.
no, no. We will close this.
No, Lordship.
Where is
before-
your prayer?
I have
Page
not
14.
yet filed my reply, Lordship. So I am praying before
This
Your
has
Lordship.
the affidavit in opposition was filed way back on 22/12/2020.
I
Miss
have filed
Council.
my wakalatnama on 14/6.
Maybe, but earlier there was another set of counsel
Lordship.
representing the petitioner.
As because,
And
Lordship,
when
yes.
when did you file your wakalatnama?
14/6, Lordship, only this month, Lordship. So I am praying for some time, but I am praying that this affidavit in opposition is not sufficient, Lordship. And Your Lordship may direct the Deputy Commissioner
No,
to
no.
file an affidavit.
This court doesn't find anything lacking in this affidavit. The affidavit is absolutely clear.
Then,
if there
Lordship,
is
I
a,
will
if
file
there
my
is a
reply,
civil,
Lordship.
absolutely, let them file then.
Let them.
Lordship.
MS
R. Chaudhary.
R. Chaudhary, Learned Counsel for the petitioner, submits that she has been recently engaged in the matter. Stop. She further seeks 2 weeks accommodation in the matter to file rejoinder affidavit to the affidavit in opposition filed by respondent number 4. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Lordship, I am deeply obliged.
5 and 6.
Lordship, in item.
Yes, instructions were required.
Yes, Lordship.
R6.
Yes, Lordship.
Yes.
Lordship, not R6, Lordship. I am for water resource. It 1, 2, 3, 4, 5.
No, on the last occasion, Mr. Chetia had appeared on behalf of R6 and sought time to file the requisite instructions. I think the instruction that was sought is there in the order dated 22/5/24.
Yes, we have an instruction. But unfortunately, in item number 6, the set of instruction is somehow misplaced. But the fact remains that
This is non-payment of contractual
Yes,
bill.
yes.
Yes.
So here the instruction, the outline of the instruction is that finally the work has been executed by the water resource divisions, but it falls under the Biswanath district. So there is a class, there is a segregation in the bills also. So these
Who
documents.
is, Mr. Borwa, the only thing that this court is concerned is that since the work have been successfully completed, who is going to now make the payments?
Make the payments. And for that matter, initially in the last occasion, last to last occasion, the Deputy Commissioner has been made a party. If at all the district is different, then the other district Deputy Commissioner, the District Commissioner also needs to be made a party, because ultimately he has to write across to the revenue.
According to you, which DC? DC?
As per my instruction, it is the Biswanath division.
DC Biswanath
yes,
division.
Yes.
I think then you make him a party.
Yes.
You make them a party because suppose tomorrow we dispose this giving a positive direction in your favor.
Yes.
Ultimately, it would be the DC Vishwanath division who has to comply with the order of this court, correct?
Yes.
Now, if he's not made a party, then perhaps there will be difficulty for execution of the order.
No, this is different district.
This is different district.
He said that it has been bifurcated. You have made
Nausib mein
the
kindly
DC Sonitpur.
Sonitpur, yeah.
Now, Vishwanath division.
Yes, division.
Is bifurcated from the Sonitpur district
That's
and has become a district.
That's what.
So therefore, in that view, all right.
Yes.
So then, shall I know? All right. Which is the instruction, Shumi? Mr. S. Borwal, Learned Government Counsel, appearing on behalf of respondent number 6,
Yes.
submits a correspondence dated 27/5/2024 received from the office of the District Commissioner Sunitpur, Tejpur, whereby it is informed that the subject work was executed by the Tejpur Water Resource Division, falling under the jurisdiction of the works was executed by Tejpur Water Resource Division, which falls under Vishwanath district. Stop.
Vishwanath division it has been.
Vishwanath division. Here it is mentioned Vishwanath district.
That's good.
Huh?
Let it be.
Vishwanath district, Vishwanath district. Stop. A copy of the said instruction is kept on record and marked as X. It appears that the District Commissioner Vishwanath district is not made up, is not an arrayed party respondent in the writ petition. Stop. MS
D. Angana.
D.
Angana. Cause list in the cause list there is
Please give it. D. Angana, Learned Counsel for the petitioner, submits that she may be accommodated to enable her to take instruction in this regard. Stop. And do the needful. Stop. Prayer allowed. Listeners matter after 2 weeks on a date to be fixed by the registrar.
Lordship, here one matter is of Kamrup Metro District.
Which is of the, I think 5408?
6 is of Kamrup.
Okay, so 5408 you write, item 5, right?
In fact, in the
5408, item 5. And in the next item, let's see
next
what it
item we have a different set of instructions.
Mr. Bora, if you want, you take photocopies, but
No,
I am
Lordship can
retaining.
retain it in the-
You have a photocopy?
Yeah.
X correct video. So that is in item 5.
5.
Yes, now in item
And
6.
in item 6 already the amount has been sanctioned, and out of the total amount, a
So
portion
then
has
I
been-
shall dispose this with a direction
Yes.
that it shall be paid within the period of 2 months.
That's true.
Yes, Lordship.
Lordship may kindly go into C, the last portion and the remaining part of the communication.
So out of
4 lakhs is it?
the sanction amount is 3,59,000 only, isn't it?
Yes.
Correct. Out of 4 lakhs, I think 3,59,97 has been sanctioned. So whatever has been sanctioned, we'll ask them to release it.
Yes, Lordship.
Mr. Bora, what does the last part means? Now, if the sanction for the remaining amounts of the aforesaid schemes received from the sanctioning authority, so and so will submit the bills of the petitioner and accordingly will release the same. This is the sanctioning, isn't it?
Yes.
What is the total bill? The total bill is 4 lakhs.
No,
4 crores.
there happens to be some difference in the amount that has been reflected, because from the petition we can find it. It is 56 lakhs. 56 lakhs. Yes. So,
do you want to verify this instruction?
I would like to verify. Just may give me 10 minutes. Time.
You wait for some time. Just find out whether it's a say. Otherwise, we can dispose it.
Yes,
of.
we can.
Yes.
Number 8.
May I please, Your Lordship?
Yes.
Lordship, here in this matter we have misplaced our file, Lordship.
Huh?
We have misplaced our file, Lordship. I have informed the petitioner, counsel for the petitioner, Lordship.
You want to reconstruct
Yes,
the file?
Lordship, reconstruct.
Health Department?
Yes, Lordship.
Your name?
D. Upamanyu.
D. Upamanyu.
Yes, Lordship.
Mr. D. Upamanyu, Learned Standing Council, Health Department submits that the records of the writ petition has been misplaced and accordingly seeks accommodation for reconstructing the same. Stop. Prayer is not opposed. List this matter after
vacation, Lord.
3 weeks on a date to be fixed by the registry. You
Hi.
please give them a copy of the writ petition so that on the next date I don't hear the same prayer.
Highly obliged, Lordship.
May I please, Your Lordship?
Yes.
Lordship, kindly produce the order dated 29/4/2022.
Personal appearance was directed in this matter.
I have received the instruction, my lord. That was conditional one, my lord.
So have you placed them by way of an affidavit?
Affidavit are not placed, my
Then
lord.
you file an
Yes,
affidavit. Why do you all keep holding to the instructions?
My lord, I have received the instruction. I will file my affidavit.
When did you receive the instruction?
My lord, it received, my lord, on 21/5, and immediately I have informed also, my lord.
That
Because-
is not the point.
My
If
lord,
instruction, you see,
because-
instructions needs to come by way of an affidavit
My lord,
so
my
that the sanctity of the
My lord.
whatever instruction is kept intact, right?
My lord.
All right, you let them file. Mr. S. Datta, Learned Standing Council, PNRT, submits that the instructions as sought for by the order dated 29/4/2024 has been received by his office. Stop. He accordingly seeks accommodation to place the same by way of an affidavit. Stop. Prayer is not opposed. List this matter after 3 weeks to enable the Standing Council PNRD to file affidavit in the matter.
Highly obliged, my lord.
On the last occasion, the respondents were directed to submit a report.
Lordship, I'm appearing on behalf of Mr. P. Nair. Lordship, we have communicated to the department, but we have not received our instructions yet.
How much more time? It's a 2022 matter.
Lordship, immediately after vacation.
All right. On your assurance, this court is giving you another chance, but because it appears this has come first time after the issuance of notice, right?
Lordship, one of my humble submission is that, Lordship, it's a 1992 matter actually. The
All right,
petitioner
but
cultivated.
you see, you have filed this petition only in 2022, right? And today it appears after, even though notice was issued on 13/5/2022, thereafter this matter was never listed. It is listed today for the first time. You have not also made any efforts to mention and get your matter listed. Now they want some time, so this is the first time they are seeking time, isn't it? So we'll give them the time, but we will definitely make it clear that they should come up with the instructions positively on the next date.
Lordship.
Heard Mr. Kedas,
Kedas.
Learned Counsel for the petitioners, and also heard MS
H. Barwa.
H. Borwa, Learned Counsel for
Mr. P. Nayak for BTC.
Learned Counsel appearing on behalf of Mr. P. Nayak, Learned Standing Counsel BTC, for the respondent numbers 2 and 4. And Mr. N. Goswami, Learned Government Advocate Assam, for the respondent numbers 1 and 3. Stop. MS
H. Barwa.
H. Borwa, Learned Counsel for the BTC, seeks how much time?
Lordship, 3 weeks.
3 weeks time to file their return in the matter. Stop. Considering that the matter pertains to
Land acquisition. Compensation.
acquiring the land,
Compensation for land acquisition.
matter pertains to compensation for acquisition of land way back in the year
1990.
1990,
1992, Lord.
way back in the year around 1992, comma, this court, by way of last chance, is granting 3 weeks time to all the concerned respondents to file their return by the next date of listing, failing which the matter shall be proceeded in accordance with law. Stop. List this matter after 3 weeks of the dated on such and such date.
20 seconds.
Ensure that whatever is filed by then, because it's a compensation matter of acquisition proceedings of 1992, and this is not only his constitutional right that has been violated, his basic human right also is getting violated. You cannot acquire a land and not give compensation. All right, not by me.
Lordship, we need some time to file the affidavit, Lordship. We have received the instruction, Lordship.
You have received instruction? Are you appearing for the petitioner?
Yes.
They have received instructions. Let them file it by way of an affidavit. Yes. You are Mr. Sahu? Heard Mr. D. Sahu, Learned Counsel for the writ petitioner. Stop. Also heard Mr.
N. Kalita.
N. Kalita, Learned Counsel for
on Industries and Commerce on behalf of A. Kalita.
Learned Counsel appearing on behalf of Mr. A. Kalita, Learned Standing Counsel, Industry
and
Commerce Department. Stop. It is Mr. So-and-so seeks 2 weeks. Mr. So-and-so submits that he has received instruction in the matter and accordingly prays to place the same by way of an affidavit. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Obliged.
Okay. Change karo. Immediate. None appears for the petitioner when the matter is called. List this matter on Friday with remark for dismissal.
Well, I am for the respondent number 8.
Yes.
Respondent number 8. My presence may come. Well, let me after vacation instead of on the.
List this matter on the reopening day, did you? With remark for dismissal, and before that you say Mr. H. Sharma. Mr. A.K. Hussain, Learned Counsel for respondent number 8, and Mr. Barwa, Mr. B. S. Barwa, Learned Government Advocate for the respondent numbers 1, 3, 4, 5 and 6. Is Ms. Baudelaire here? Are present. You are there, Mr. Barwa, Revenue? Mr. A. Bhattacharya, right? Learned Standing and Mr. A. Bhattacharya, Learned Standing Counsel, Revenue, are present. Huh?
Hello.
Yes. Compensation, electrocution debt, APDCL?
Yes, Lordship.
Yes. Government, have you filed your electrical inspector's report?
The report is not Maybe some time.
You do one thing, I'm fixing it after vacation.
Yes.
In the meantime, if it has not been filed, you file it. Mr. S. Borwal, learned government advocate for the state respondent, seeks 1 week time to bring the report of the Chief Electrical Inspector, APDCL. What is the designation? Chief Electrical Inspector, something is there, I think.
Yes. Nowadays it keeps on changing. Electrical Inspector. Respondent 2 from the respondent.
Report of respondent number 2 on record. Prayer allowed, list after opening date of the deduct. Second week deducted, by then he will have sufficient time. Mr. Bora, I'm giving you sufficient time.
Yes,
have it on record.
We have the vacation in between. Bless you.
Lordship, matter relates to
Contractual dues. Yes. Pending since?
Your Lordship, there is some confusion regarding my instruction, my Lord. I will be allowed.
There is some confusion?
Yes, Your Lord.
What is the confusion?
My Lord, as per instruction, my Lord, petitioner file inspection report, my Lord. Petitioner file inspection report, but as per instruction of the executive engineer, there is no inspection report.
Anyway, you get it verified. Is this an admitted due?
Yes, Lordship. Yes, Lordship.
Where? Which document?
Pardon.
Which document shows that the bill of the petitioner is admitted by the state respondents?
Lordship, page number 14.
Executive engineer has already verified
Yes,
and
my Lord,
certified rupees 3,90,944.
But my Lord, as per their instructions, my Lord, the record is, this document is not in the record, my Lord.
All right. You're right. Heard Mr. D. Kalita, Learned Counsel for the petitioner, stop. Also heard
DS Neogi.
MSDS Neogi, Learned Standing Counsel, Irrigation Department, Assam. Stop. Though the executive engineer, though the jurisdictional executive engineer has certified the bill of the petitioner amounting to rupees 3,19,944, non-payment of which is under challenge in non-payment of MSNDS Neogland Standing Council submits that from the instruction that she has received from the department, it appears that the record of the said certificate is not available on record. Stop. Accordingly, she seeks some accommodation in the matter to ascertain the veracity of the document which is enclosed as Annexure C to the writ petition. Stop. Prayer allowed. List this matter after 2 weeks on a date to be fixed by the registry. This is your. This is what it says, right? This Annexure C document you are saying is not available on record.
Yes, sir.
But why do they take so much time? Iman time क्यों लगे आई बोले रखी I've been asking call करा नहीं कि तुम्हारा
May I please Lordship?
Yes.
Made me Lordship.
Yes, Mr. Burago.
Yes, my Lord. Here, my Lord, the matter pertains to, my Lord, on payment of the contractual bills, my Lord, amount which are due to be paid to the petitioners who were, my Lord, had rendered their unblemished services to the Nagaon paper mill and, my Lord, Kasha paper mill, erstwhile HPCL, my Lord. Now, in between what happened, your Lordship is well versed, my Lord, that the entire liquidation process was initiated, and, my Lord, the assets of these corporation, my Lord, corporate debtor has been sold out to the Assam, has taken over by the Assam government, more particularly by the AIDC, my Lord. Now, AIDC at a very nominal price has bought the entire asset at 375 crores, which was initially, my Lord, auctioned at 1100 crores. So anyway, we are not on that point, my Lord. Now the question is, my Lord, after taking over the assets at 375 crore, now the government, now they have introduced some additional financial packages for the ex-employees, contractual workers, and other persons of the corporation, leaving aside the claim and the grievances of the current petitioners. Now, we were the suppliers, and my lord, we were basically my lord, involved in giving raw materials like bamboo, etc., to the corporation, my lord. Now, what the government did subsequently after taking over, or in fact during the process, they took a policy decision that we will bail out these people outside the purview of the amount from where they have taken over. Meaning thereby, my lord, 375 crore was the amount they have, my lord, taken over the mill. Now, outside 375 crores, at 810 crore, financial packages has been introduced.
So your grievance basically appears to be that financial packages that has been introduced, you have been left out.
Exactly.
And it is only for the past employees.
Yes, ma'am.
You are the suppliers.
Yes, ma'am.
The suppliers are not included
in that additional package.
In that additional package.
So
that is the grievance.
Yes, ma'am. Simple.
Yes, what is your instruction?
Lordship, we have filed our affidavit, Lordship.
Yes. What do you say in your affidavit about this grievance of the petitioner? Why have they been left out? Why does pick and choose? What is the rationale for pick and choose?
Lordship, actually my senior, he is in Lex.
Who is your senior?
J.K. Goswami, Lordship. J.K. Goswami, Lordship.
But you are also there in the matter. Have you signed the Wakalatnama or not?
So, yes, Lordship.
Then,
Lordship,
why are you not prepared? You don't even know what is in the affidavit. You are respondent number 5.
Yes, Lordship.
Where is the affidavit? 10th May 24.
Yes, my lord. 10th May.
The court has to do all your work. You don't even know when the affidavit has been filed. Yes, Mr. Buragoy, what is the stand in the
Their basic stand is, my lord, very simple. What they say, they have given this relief to these people on humanitarian ground. This is a very, my lord, I do not, my lord, disagree. Let them take this call on humanitarian ground. But why we were left out, they are completely silent.
That is exactly what
we are also saying. That is exactly what our case is, my lord. But we are seeking, my lord, basically parity of treatment under Article 14. So if you are discriminating us.
So the affidavit doesn't disclose the reason?
Reason is humanitarian ground, my lord. And secondly, that our liquidation process is taking place. And because the liquidator is there to take care of our claims.
Alright, then I'm admitting this.
Yes, my lord.
And posting it for hearing.
Yes, my lord.
Alright.
That may be. I'm obliged, my lord.
Item 21, Rakhi. Heard Mr. H. Buragohai, Learned Counsel for the petitioner. Stop. Also heard Mr.
DJ Bora, Lordship.
DJ Bora, Learned Counsel for the respondent number 5. And Mr. N. Kalita for Mr. A. Kalita, Learned Standing Counsel, Industries and Commerce Department. Mr. Borwa is also there? No. And Mr. S. Borwa, Learned Counsel, Learned Government Advocate for the State Respondent. Stop. The issue involved in the present writ petition requires a full-fledged hearing. Stop. Admit. Since parties are represented, no formal notice. List the matter for final hearing. Yes, date.
Any date convenient to my lord. I have no issue.
August or did you get a, maybe in the middle August or end of August? On such and such date.
Lordship, they have filed affidavit and reply, but we have not received the affidavit and reply.
That is also incorrect, my lord, because nowadays.
Anyway, Mr. Buragohai, there is no harm in giving him a copy. I'm not recording all this in the order.
Yes. Obviously, serve them a copy, madam. I'm deeply obliged, my lord.
Yes.
My lord, may kindly peruse order dated 16th of February.
Yes, I have the order in front of me. Mr.
So,
Talukdar, NHIDCL.
I've got the instruction that the whatever estimate prepared by the additional lordship executive engineer, my lord, that is to be challenged before the arbitrator, my lord, as per my instruction. So let it be after vacation, my lord. I will obtain the report.
But I think this court's order on 16/2/24 specific instruction was the present status of the claim.
Yes,
now
sir.
you are saying this has to be submitted before the
lordship arbitrator.
It is already there.
It is already there, my lord.
It's already there.
Yes.
The statement is already there.
Yes. It's 12/9/23.
Yes,
Yes.
lordship.
So, as per this honorable court order, dated, my lord may peruse 9th of August 23, this was to be done, and that is done. Still, they are not.
No, have you submitted?
My lord,
As per this instruction,
my lord.
it says that.
My lord, may kindly peruse firstly 9th of August order. It will clarify everything.
Which order?
9th of August 23.
Yes.
So PWD was directed to verify the verify the building and submit a
9 August?
9th of August, yes.
2 copies be furnished so as to enable him to obtain instruction and apprise this court as to whether the report called for from the DC has been submitted. Now, what about this instruction?
Then kindly come to order dated 6th of February. It will clarify all things.
Mr. Nath, place a copy of the letter dated 12/9, whereby he had forwarded a valuation estimate in respect of that part of building belonging to the petitioner to the ADC, who is the competent Kala.
That is
submits that despite such valuation, no compensation amount has been assessed.
So if
Yes, your instruction was what is the status? What happened?
Lordship,
they are just beneficiaries.
Lordship,
claim
that
is pending before the competent authority.
competent authority, Lordship.
Then
So
competent authority is the authority to
who is it? Yes,
additional deputy commissioner
Mr.
Golaghat.
Burma? Yes, Kala.
Kala kam ADC. Golaghat. So according
What
to
has happened to the claim of the petitioner? It appears it was forwarded.
So after passing of the February order, I sent my client to visit additional deputy commissioner. He said whatever I will submit before the High Court. I will not tell anything to you.
But
so
as-
that is the position. Ma'am.
Now he is not telling anything to the court also.
That is correct. And it is from February, and the building is
Yes,
already
Mr.
damaged.
Burma. Huh?
Building is already partially damaged, and due to the heavy rain, the leakage is already there.
When was the building taken?
In the year 2022. So actually, Malab, in short, if I say, it was a common building. So half of my part was my cousin's brother, and other part is my part.
Mr. Borwal, this court has been continuously observing for the last few weeks that this court has taken this bench, that these matters relating to compensation, acquisition, are being very casually dealt by the respondent authorities. These are not just some statutory rights. These are the basic human rights that one is dealing, a constitutional right, isn't it? It may not be a fundamental right anymore, but it is definitely a constitutional and a human right. How can the instruction sought doesn't come, one is sitting over the claim?
That is correct.
Various different excuses are being always brought to the notice of the court.
And every time there must be a court order. Then only they can.
This cannot be allowed to go on. At some point, serious strictures will be laid down. I'm telling you, Mr. Borwa. Please send the signals to the government officers. They cannot be so casually dealing these matters. All that the Kala is to do is consider isn't it? So that whether what he has done, that is also not placed before the court. On the last occasion, it came on February. Now we are in end of June.
Interestingly, my lord.
Mr. Borwa, why this court is communicating with you is because you are before this court, right?
I'm understand.
So that you send a letter. Obviously, I'll give you some time today, but you put everything in the letter. Let the authorities also know as what they are handling, isn't it? They cannot be acting so casually.
It seems so.
So, how much time do you need? Because all that this court is concerned is what has happened to the claim, which is pending, admittedly, before the additional district commissioner Golaghat. See, if this does not come, you may tell this court may indicate that this court will consider directing personal appearance otherwise.
Yes.
This cannot go on like this.
In fact, if going by the records, one communication has come in 2023 whereby some technicalities has been seen as regard the work that has been executed, Accordingly, PWD has been asked to go and make a.
That is of when?
2023, August.
Of when? Which year? Which
2023.
year? I know. Which year? Sorry, which month?
Month is August.
Now in September, they say that they have sent it.
PWD.
Yes, the instruction is there. This is of 12 September 2023. Submission of valuation estimate. This is done by Executive Engineer PWD.
Amount is also fixed.
Correct.
Okay.
And this has been done before the ADC.
ADC.
He is the competent authority. So what has happened thereafter? This is exactly what the court wants to know.
This is immediately after that inspection has been asked to be done.
Right.
So after these, the action that has been taken, so we will have a instruction and we will place it.
No, all that you need to know is what the ADC is doing.
Last occasion.
16/2/24 order.
Yes.
Do you have a copy?
I don't have a copy.
Edu Diokson. Have a look, Mr. Bora. It's a very clear order.
So this is very clear.
See, that is why this court is saying that, you are now understand why I use the word casual.
Yes, yes.
Despite such
because
orders
after the
being-
report, they have
Absolutely.
been
That's
specific.
all.
That's very simple. In fact, if at all they wanted to come up with a...
Whatever be it. But something must be done, no? Because
So
you
let-
cannot be depriving the petitioner of his
just a week's time.
constitutional human rights.
Yes, yes.
Isn't it?
I will ensure that it comes by the next day.
It appears that the instruction as sought for by this court by order dated 16/2/2024 is still not placed before this court. Stop.
16
This court depreciates
16 no?
depreciates the casual approach adopted by the respondent office in dealing with matters where the constitutional, statutory and human rights are at stake. Stop. Be that as it may, in view of the assurance given by Mr. S. Borwal, learned government advocate for the state respondent, this court, before passing any adverse orders, grants 2 weeks' time to the state government to place the instructions as called earlier by this court by order dated 16/2/2024. Stop. List accordingly.
Okay.
Shall I give a date?
Yes, Lordship.
List on such and such date. Please have it, Mr. Boro, and you enclose both the orders in your letter.
Already.
Maybe pass over timing. Timing.
Pass, Kiman Masa 39.
39.
Time. All right.
Timing.
40.
May it please your Lordship. Lordship, the petitioner before your Lordship is a 85 years old lady, my Lord. She is claiming ex gratia compensation.
This is that, yes. Is this that security office, that case? No. Yes,
Pardon,
on
my
what basis are you seeking for ex gratia?
My Lord, as per office memorandum dated 22nd June 2004.
If a government servant amongst others died due to extremist attack.
Yes, ma'am.
On that. Yes. What is the stand of the respondents?
The respondents have filed their affidavit, my lord. Respondent number 5.
Yes.
My lord, here in this affidavit, I would like to point out certain things, my lord. Page number 33, my lord. This is the second round of litigation fought by the petitioner, my lord. And on the earlier round of litigation, my lord, the petitioner approached before this court by filing WPC number 6521/2014, my lord, which was disposed of, my lord, directing the respondents to cause an inquiry, my lord. And if upon such inquiry, my lord, if the petitioner is found entitled, my lord, the respondent authorities were directed to release the sum.
That inquiry was made?
Yes, my lord. Inquiry was made.
Yes.
Thereafter, my lord, page 33, my lord.
34 upon receipt of the order.
Affidavit filed by the respondent.
Yes, I have it. I think that paragraph would be important. Yes, I remember this matter. Now you see, the petitioner's son was a school teacher.
Yes, my lord.
But he is not a government employee. The memorandum, where is this office memorandum 22/4/2004? Where
On
is
the
it?
earlier occasion, I have provided it before the court, my lord. And one office memorandum, my lord, that the respondent has said will cover my case is marked as Annex X, my lord. And the affidavit filed by the respondent number 3, my lord. Herein in this affidavit, my lord.
One second. Ms. Bodler, you are in this matter?
This matter, Your Lordship, Finance Department has filed its affidavit, Your Lordship.
Yes, my lord.
It is stated in page number 26, point number 3, Your Lordship.
Yes, please read it out.
Yes, Your Lordship.
Finance affidavit.
Yes, Your Lordship. Mr. R. Pujari will be appearing, Your Lordship, is on its way. Lordship, here...
affidavit of R5.
No, Your Lordship.
No.
R3.
Respondent 3, my lord.
R3, please hear, Your Lordship.
Mr. Warpujari, you are appearing in this matter.
Yes, my lord, on behalf of the Finance Department.
Where your affidavit I am trying to locate.
Yes, ma'am.
Here, admittedly, the petitioner's son is a school teacher.
Yes.
And on the basis of one OM dated 22/4/2004, he is claiming the ex gratia, right?
Absolutely.
But that OM says it, if a government servant has been attacked in an extremism. Correct. Now, where is that OM? I'm trying to locate that OM first. Because the petitioner is claiming the ex gratia on the basis of this OM, correct?
Yes, OM, and otherwise, my lord, he is aggrieved by, my lord, the speaking order that lordship will find at page 17 of the writ petition.
Page 17?
Page 17. Whereby, my lord, his claim has been negated.
This is an inquiry which was done after the first round of litigation.
Yes.
All right. Let's read this.
Yes.
This is under challenge.
This is under challenge. We read, my lord, the order dated 3/6/2015 passed by the Honorable Guwahati High Court in WPC number 6521 of 2014, Vishnu Maya Kafle, State of Assam and others. Also read the report dated 24/2/2015 of Superintendent of Police Kokrajhar and report dated 6/11/2015 of Circle Officer Dotoma Revenue Circle Kokrajhar. Also read the office memorandum number so-and-so dated 6/6/1996. Peruse the order dated 3/6/2015 passed by the Honorable Guwahati High Court in respect of WPC number so-and-so, wherein it has been mentioned that the petitioner's son, Kulo Prasad Kafle, went missing since 6/1/2001. The petitioner Srimati Vishnu Maya Kafle has approached the Honorable Guwahati High Court by way of WPC number so-and-so, praying for payment of ex gratia grant on the ground that her son might have been kidnapped or killed by extremists. Also peruse the report dated 24/2/2015 of the Superintendent of Police Kokrajhar, and report dated 6/11/2015 of Circle Officer Dotoma Revenue Circle, Kokrajhar, which ascertained that Kuloprasad Kaple was working as an assistant teacher at number 1163 Bhauraguri LP School.
What does it mean? Is there any office memorandum or guidelines for granting ex gratia to such cases?
Yes. That, my lord, they have not submitted, but it is there, my lord.
My lord, affidavit in opposition filed by the respondent number 3, my lord, page 29. There is an office memorandum.
29?
Yes, my lord.
So, your son, was your son a government employee?
Yes, he was an assistant teacher.
He is admittedly a government employee.
Yes, ma'am.
Which page?
Page 29, my lord. Affidavit in opposition filed by the respondent number 3, my lord. They have said that I am covered by this office memorandum, my lord.
29 July.
No. This affidavit is filed, my lord, by the finance department. The OM lordship, therefore, my lord, I am drawing my lord's attention to page number 17. In that case, my lord, the OM which was in force, my lord, is of 1996. Kindly see, my lord.
6696.
Absolutely, 6696, which was issued to provide ex gratia again to the next of kin of missing persons.
When did the son went missing? 6/1/2001.
6/1/2001. Who were abducted and killed by extremists on or after 1/8 in 1985. As per para 4 of the said office memorandum. Lordship,
Do you have the 6696?
Yes, my lord, I am trying to locate it.
Because, Mr. Counsel, this 29 is of 2006.
Yes, my lord.
But your son went missing in 2001.
Yes.
So this court will have to see which is the OM which is in existence at that time. You cannot bring in some subsequent OM and say you give me ex gratia as per that.
Yes.
Isn't it?
I am not saying it, my lord. Respondent number 3 has said.
Alright, we
By way
will
of their
come to
opinion.
that. Yes, Mr. Barpujari, where is 6696?
My lord, I am trying to locate it, my lord.
Who is R3?
R3 is, my lord, the finance department.
So you are representing R3?
I am representing
Where
finance.
is the averment in support of Annexure A29? Which is the averment?
My lord, page 29.
That lordship will find, my lord.
Page 29.
20?
27 of the affidavit, my lord.
But it is a part of, my lord, page 26. Because what has happened here...
One sec, Mr. Barpujari. Have you found that OM?
My lord.
You find that till that, let me read para 3.
My lord.
Here, but in this case, was the teacher engaged in any counter-insurgery operation of the state?
No. Because this argument has been developed after filing of the writ petition. It was never the case of the writ petition, my lordship. Therefore, kindly see the prior portion of the writ petition, my lord. That lordship will find, my lord, at page 10. Page 10 of the writ petition. It was never the case of the writ petitioner that the writ petitioner...
Here, they have said it is, even this 2976 is also inapplicable.
Yes, it is not applicable.
See, if you won the ex gratia, you have to show the court that there is some office memorandum which allows. Now you are, the OMs that you are relying are not helping your case.
Yes,
the report which has been submitted by the circle officer pursuant to the order that you had got in the first round is also not supporting your case.
Yes.
In that case, if you cannot come up with anything, this court is going to dismiss.
My lord, I would like to point out page 17, my lord.
Yes, page 17 is
Page
the order
17, my
which you have challenging.
Yes, my lord.
This order is very clear.
Here they have regretted my case because they said that they are not the competent department to decide my case, my lord. The
No, not only
competent
that.
department is education department, my lord. To
No,
decide my case.
no. I think they are also saying
Here, my lord.
The
Here
last
said
but
there are 1, 2, 3, 4.
The last
fourth
but
para.
one paragraph. The
Fourth
last
para,
but
my
one
lord.
paragraph.
since Kul Prasad, that paragraph.
Kafle, my lord.
Yes,
Kafle
Kulaprasad Kafle was a
school
school
teacher.
teacher. The Relief and Rehabilitation Branch of Revenue and Disaster Management Department is not the competent authority to sanction of act cashier grant to his family member next of kin. The matter may be taken up with the concerned administrative department, education department. It may be taken up. If at all he has
No,
any...
but under 6696, is he entitled?
6696, my lord, they say, my lord, he is not entitled because he is, my lord.
It says as per para 4 of the OM, the cases of government employees will not come under the purview of this OM.
Absolutely.
So you are a government employee.
Yes.
So then how will you be? They have already rejected. Are you understanding what I am saying?
Yes, ma'am.
This inquiry itself says you are not entitled. Nonetheless, they say ki you can go before the other authority. But they have clearly said, and the affidavit of the finance department further clarifies that even the subsequent OMs, you are not covered.
Yes.
Then, on what basis?
My lord, thereafter several correspondence has been made, my lord.
Correspondence will not give you any right, Mr. Counsel.
In that case, my lord, I would like some time, my lord. I need some time, my lord.
All right. Instead of dismissing it right away, let him
Yes, my lord.
let him try if we can satisfy the court.
Because
Otherwise, sorry, I don't think you have a case, Mr. Counsel.
My lord, one fundamental flaw which we have observed here, my lord, writ petition ought to have annexed, my lord, this OM dated 96. It was his duty. He is the dominus leti. So if he is at all
See,
agreed,
that is why this court is posing the question that under which OM are you entitled? So
Well,
if he is not challenging, we will not go into that.
Right.
Admittedly, the report says he is not covered.
He is not covered.
He is
So
not
he
covered.
will have to place, my lord, sufficient contra materials against the report.
Correct.
That is
Otherwise,
not a matter.
this court finds no infirmity
Absolutely.
with the order of the circle officer.
Absolutely.
It's based on the reading of the OM, which says that government employees are not covered unless you show me the OM and show that no, it says that government employees is covered and this has been wrongly done. That you are not doing. You have not even annexed that OM. Where is that OM? Have you annexed it? That very OM you have not annexed. How do you want this court to go into all these questions? You see, you have to place the facts. Then only this court can apply its mind. So you get hold of what you want. I'll post it after. I'm giving you. I'm posting it after the vacation. Hearing remain inconclusive. But this is in the admission stage, right?
Yes.
Then let me admit it.
No. It has not been admitted. Lordship may keep this as part heard, my lord, for admission hearing. But since Lordship has heard the matter at length, my lord, kindly, my lord.
Admission, I don't think it looks proper if you keep it for part heard.
Otherwise, my lord has already heard substantively, my lord. The only issue is that much only, my lord. I will also, my lord, get hold of that OM, my lord, even if he doesn't.
Hearing remains in. You say that this matter, though, is listed for admission, comma. However, as per the request of both parties, the matter was taken up for final disposal. Stop. During the after hearing the matter, after hearing the parties, comma, it appears that the OM dated. What is the date of the OM?
My lord, it is 6/6/1996.
1996.
My lord.
Is essential to be perused. Stop. Let the same be placed on the next date of hearing. Stop. List on such and such date.
I am deeply obliged, ma'am.
I am so obliged, my lord.
May I please, Your Lordship? My Lord, on the last occasion also the petitioner was absent, ma'am.
None appears for the petitioner when the matter is called. Stop. Mr.
P.H. Kaur, my Lord.
P.H.
P.H. Kaur, my Lord.
P.H. Kaur, learned counsel for respondent number
2, my Lord.
2 is present. Anyone else? Government, are you here? And MSU Das, learned additional senior government advocate, Fishery Department.
Fishery, my Lord. If it is, yes, my Lord, we can appear because prior
Learned
to...
additional senior government advocate for respondent number 1.
My Lord.
Stop. It appears that on 21/6/2024, when this matter was last called, comma, since there was no representation on behalf of the petitioner, comma, this matter was directed to be listed today, i.e. 25/6/2024, with the remark within quotes for dismissal in the cause list. Stop. Next part. Despite the matter having been listed today in the call with the remark within quotes for dismissal in the cause list, comma, there is no representation on behalf of the petitioner. Stop. Accordingly, this writ petition stands dismissed for non-prosecution.
Obliged, ma'am.
Disposed of.
Item number 6.
No, 43 to Matil Lawata. Then I matter. Complete code of Asudia. This is item number 6. Yes.
So after going through this set of instructions, what I can make out is out of the total amount for 2 different schemes, the petitioner's entitlement is only for 56 lakhs. So now what it says is that out of the total scheme, this amount, administrative approval has been given only to sizable amount of the total amount, and from that sanctioned amount, petitioner's bills are not included. So once that approval is received from
I think you filed an affidavit, Mr. Borwa.
Lordship, for that matter, before an affidavit, the Revenue Department has to give their approval. Once the bill, then the bill will be submitted by the concerned department, that is the water resource, and after that the disbursal will be done by the
department. Have you shared this with the petitioner? I think the petitioner deserves to know what is happening.
Yes.
That is why I'm saying you put this by way of an affidavit.
So more than affidavit, I think if at all the revenue also comes up with their set of instructions, because ultimately the approval has to be done.
Who is appearing for the Revenue Department? Ms. Bordla, have you gone through these instructions?
No, Your Lordship.
Have a look at the instructions.
If they have sent a proposal to the Revenue Department.
No, now let me understand one thing. Out of the bill that the petitioner has submitted, some of the bill have been sanctioned.
Not petitioner's bill.
So then,
different 2 sets of work have been executed.
That is why I'm asking you to put it by way of an affidavit is because of this.
Yes.
Because had it been petitioner's bill, this court could have disposed it of.
Could have been disposed of.
But how can this court dispose of this matter on the basis of instruction which has adverse materials against the petitioner? Because her case is not yet considered the petitioner's bill.
Not considered, not even denied.
Not even denied. So what is the status?
So status is that once that approval amount is received from the Revenue Department, the water resource will submit the bill before us, and the Deputy Commissioner is only with the
bill is now pending before the Revenue Department.
Yes.
For sanction.
Yes.
Is it correct?
Yes, that is what it reflects.
The instruction says.
Yes.
She will seek instructions.
All right, let me record this part.
Yes, lots of may have it.
You are following what is happening?
Yes.
You are following what is happening?
Yes, Lordship.
Mr. S. Borwa, learned. Mr. S. Borwa, learned government advocate for respondent number 6.
Yes, Lord.
Places the instruction dated 21/6/2024 received from the office of the Deputy Commissioner, Kamrup Metropolitan District, Guwahati, whereby it appears that the petitioner's bills is pending before the sanctioning authority, i.e. Revenue and DM Department, and only after the sanction is issued, the Water Resource Department can submit the same to the District Commissioner Kamrup M's office for release. Stop. Let MSN Bordaloy, Learned Standing Counsel Revenue, obtain instruction in this regard and positively place before court as regards the status of the petitioner's bill by the next date of listing.
The date may be fixed.
Yeah, tell me.
Your Lordship, in the month of August, Your Lordship, 5th.
Rupa, 5th. List again on 5th August.
Little bit early, Lordship.
Let her get the instructions because have it in the end of July.
Yes, Lordship.
You will not be. All right. 5th, 5/8/2024.
Lordship, I may have a copy of the instructions.
A copy of the said instruction dated 21/6/24 may be furnished to the Standing Council Revenue to facilitate her to obtain the instruction sought by this court.
Deeply obliged.
Yes, Lordship.
I'm returning this, or should I keep this?
I will have a second copy and I will just place it before the court.
Madam Likhija, a copy of the said instruction is also kept on file and marked as X. Kind of. Mr. Borwa, I'll say in the meantime you file file an affidavit bringing this instruction on record also. It will be on record then. No? In the meantime, Mr. S. Borwa shall bring the aforesaid instruction on record by way of an affidavit also. Okay? Now don't say mark X. Return it. Yes.
Yes, my lord.
Kiman Matila? 43 to 40. On the last occasion,
my lord, I missed the bus. Actually, I am court number 1 when I rushed there. Matters already over. Sorry
all right,
for that.
then we'll have it on another date. We'll
Lordship,
record his
after
presence.
application.
Since there was no representation on 21/6/2024 on behalf of the petitioner when the matter was called, this matter was listed today with remark for dismissal. Stop. However, today when the matter was called, Mr.
M.J. Borwa.
M.J. Borwa, Learned Counsel for the petitioner, is present. Stop. Let this matter be listed for admission. For admission on, yes, give a date.
Immediately after vacation,
Mr.
because the
Goswami,
petition also waiting.
when do you all want? Yes?
16 or 7.
No, my lord, let it be on 19, my lord.
19?
19.
On 19/7/2024.
Obliged.
Item number 24.
My lord, pleading already completed, my lord. I have filed my affidavit in reply.
So it's a contempt case.
Contempt case, my lord.
Yes, Mr. Thor.
My lord, we have complied. My friend is to now understand, my lord, the thing that this is the contempt of 2020, my lord.
Where is the order?
Direction of the court, my lord. My lord will find.
One second, let me hear the
My
petition.
lord, order is page 8 of the contempt petition.
Page 8.
Yes, my lord.
My lord, this is a simple direction to the state level scrutiny committee to
operative part is page 10, my lord.
10, my lord. Second para to reach.
Yeah.
To make an application before SSSC.
Yes, my lord.
And when application is brought, a decision with regard to the caste status will be made.
My lord.
Yes. Now, first of all, have they made an application?
No, my lord. That is what
they have not made.
They haven't made, but my lord, when we have come to know after this contempt, we have twice communicated to him.
Where are those?
These are on affidavit, my lord.
Where is your affidavit?
My lord, affidavit filed on 39/2020, my lord. My lord will find
affidavit filed on
30/09/2020 by Ajit Naran Hazarika, A.N. Hazarika, my lord.
A.N. Hazarika.
My lord.
Yes.
Now my lord will find, I'm just taking straight to the, my lord, communications, my lord. My lord will come to page number 8. First.
Yes.
Page number 8, my lord.
Yes.
My lord, the deputy secretary writes to, my lord, he is a member secretary of that committee, my lord.
All right, I have seen, not received.
Not received.
Yes.
Then, my lord, the second page, next page, my lord, page number 9. This is a, my lord, WT message through police.
To whom?
To this petitioner, my lord.
Dispol.
Yes, Dispol, that is police communication. We have taken, my lord, extra precaution that he receives it.
Okay.
My lord will find, refer to letter 3 of Hiralal show such and such. What happened, my lord, in para 7 we have stated.
All right, anyway, then...
Means we are trying to contact him, my lord. He has to come before this committee.
But Mr. Counsel, the order of the court is absolutely unambiguous. It says that as in when application supported by necessary documents are brought before the committee. So the first prerequisite is that the petitioner has to make an application. Has the petitioner made this application?
Yes, my lord. Kindly
yes. Where?
Page 11 of my contempt petition.
You have denied receiving this?
My lord, the receipt is with me, my lord. Original receipt is with me, my lord.
No. What is your averment to this?
My lord, we said that we never received it, my lord.
My lord, apart from this, my lord, what my learned colleague has...
Now, my lord will find exactly, that is what, my lord. He has submitted this before the welfare of scheduled caste. This is a directorate. He has, my lord, he has to go to the committee. Committee is in Dispur, and this document is somewhere else.
I am dismissing this contempt petition because there is no contempt, there is no willful disobedience.
That is
Mr.
what,
Counsel, the law of contempt is very clear. It is once your role is limited, you are only to bring to the notice of the contempt, and thereafter it is between the court and the contemptor. Now, I have heard both the parties, and it appears that the order of this court was absolutely unambiguous, which said that you first file the application before the committee. Now, you have said that you have filed it before some directorate of welfare.
No, my lord, the state level committee.
No, but the seal that you is appended to this letter is of this department, and
that is not even in Dispur, my lord.
So
that's a different.
You have not filed it before the before the committee. Then how do you expect them to do it? Anyway, I am resuming in 5 minutes.
My lord, I kindly have a look of my affidavit in reply, paragraph number 2. That as regards to the apartment made in para 6 of concerned annexure to the contempt petition is having received of with the petitioner, and the petitioner claims the leave of the Honorable Court to furnish the receipt copy of the application at the time of hearing. Apart from this, the petitioner, after awaiting many months, the authority given notice to the petitioner date on 10 September 2020, which received by the petitioner for submission of documents relating to claim of scheduled caste. Accordingly, the petitioner submitted his documents through online. By that time, my lord, Kovid was there, to the authority along with all relevant records. Prior to the said email sent to the petitioner, already submitted records along with the copy of the writ petition and the order of the Honorable High Court. The same was duly received, even though ignoring the same. There is no state level committee. Only before the director, this office, this copy was submitted, application was submitted. There is no state level committee. The application was submitted in the office of the directorate, my lord, and they will forward it. My client has told me, my lord.
My lord, I am just placing a notification that this is absurd, my lord, that there is no state level committee, my lord. Every day, my lord, state level committees, my lord, taking up matters, so many matters being forwarded by this honorable court and other authorities, my lord. Why there will be no?
They have received, my lord. If since they have received, it is their duty to forward it. Apart from this, my lord.
And my lord, the bigger thing is that there is no mode of, my lord, filing a application online, my lord. He has to appear, my lord, before the committee. There will be examined. Those are the procedure, my lord. It's like a quasi-judicial, my lord, court, my lord.
What is this? 11 May 18?
This is, my lord, the formation of that committee, my lord.
11 May 18.
My lord. My friend is telling that there is no committee. That is what I'm just.
My lord, this committee, there is no office as a committee. Only this. The directorate office, it has to be given.
My lord, director office is in Horumotoria, whereas.
Yes.
Whereas, my lord, the committee is in Dispur, my lord.
And they have received it. Apart from this, my lord,
my lord will come to page 11, my lord. There is no, my lord, receipt note by this state level scrutiny committee. Whenever a committee receives anything, my lord.
All right. Please take your seats now.
My lord, I accepted this.
Mr. Petitioner, Mr. Counsel,
kindly have a look at my
please
paragraph
understand that you are before a contempt jurisdiction.
Yes, my lord.
The only limited right of hearing is that your duty is to bring it to the notice of the court, which you have done.
Yes.
Thereafter, it is between the court and the contemner.
Yes.
Now let me do my duty. Please sit down.
My lord, kindly look paragraph 3 and then pass the order.
All right. Paragraph 3
of my affidavit in reply, my lord. Page 22, my lord. The petitioner received the W2 message.
Please take your seat, Mr. Counsel. Heard Mr. I. Talukdar?
Yes, my lord.
Learned counsel for the... You are Mr. Talukdar?
Yes, ma'am.
Learned counsel for the...
Petitioner.
Stop. Also heard Mr. R. Dhor, learned counsel for the sole respondent.
Yes, sir.
Who is for 2? For contender number 1. Stop. By filing the contempt petition, by filing this application under section 11 and 12 of the Contempt of Court Act 1971, read with Contempt of Court within bracket Guwahati High Court Rules 1977, the petitioner is drawing notice of alleged willful disobedience and violation of the order dated 28/2/2019 passed by this court in WPC number 5617 of 2018. Stop. By order dated 28/2/2019, this court in the said WPC 6516 of 2018, where the issuance of caste certificate in favor of Isha Shaw, daughter of Jawaharlal Shaw in WPC 6516/2018, and in favor of Avinash Shaw, son of Hiralal Shaw in WPC 5617 of 2018, was involved. Stop. In this case, it is Hiralal Shaw.
Yes.
The petitioner is Hiralal Shaw.
Yes.
In the case, it is due to the this court in disposed of the aforesaid writ petition with the direction that to reach a definite conclusion as regards the case status of Isha Shaw and Avinash Shaw, the proper procedure would be for the respective guardians to make necessary application before the state level scrutiny committee. And as and when such application supported by necessary documents are brought before the committee, a decision with regard to the caste status of Isha Shaw and Avinash Shaw will be made by the state level scrutiny committee within a period of 4 weeks from the date of making such application. Stop. Initially on top where I have said Avinash Shaw, son of Hiralal Shaw, within bracket petitioner. Correct? Petitioner. It is the specific case of the petitioner that despite an application dated 19/3/2019 being filed before the state level scrutiny committee, the committee is sitting silent over the matter in sheer disregard of the order passed by this court. Stop. Accordingly, the instant contempt petition has been filed. Stop. Mr. I.A. Talukdar, next para. Mr. I.A. Talukdar, Learned Counsel for the petitioner, submits that despite the application having been filed in terms of the court's order, the concerned respondent, the contender number 1 is sitting silent. If contender number 1 has not complied with the decision of this court. Stop. Next para. Mr. R. Dhor, Learned Counsel for the contender number 1, on the other hand, submits that the petitioner has not filed the application as he was required in terms of the order dated 28/2/2019, and as such no case of contempt is being made out against the contemner. Stop. Heard the submissions of the parties at length and perused the materials available on record. Stop. The order of this court dated 28/2/2019 is absolutely clear and unambiguous which required to the effect that it required the petitioner to make necessary application before the state level scrutiny of committee, and only upon such application being received by the state level scrutiny committee, supported by necessary documents, comma, a decision with regard to the caste status of the petitioner's son and Isha Shaw will be made by the said committee within a period of 4 weeks from the date of making such application. Stop. Though it is contended on behalf of the petitioner that on 19/3/2019, an application was filed before the state level scrutiny committee Assam, scheduled caste and scheduled tribe Dispur, the original copy being produced before this court, appears that the same has been received by the Directorate of Welfare of Scheduled Caste Assam, Guwahati, on 19/3/2019. Stop. It further appears that the contemner number 1, by filing its affidavit in opposition, categorically averred that since no application whatsoever in terms of this court's order dated 28/2/2018 was received by the committee, the Deputy Secretary to the Government of Assam, WPT and VC Department, by letter dated 10/9/2020, requested the petitioner to submit application in terms of the application before the chairperson of the scrutiny committee. Stop. It further appears that the said department also, by a WT message dated 15/9/2020, once again requested the
Officer to communicate.
No. So then let me not go into this. Stop. paragraph 6 7 of the said affidavit in opposition is reproduced hereunder for ready reference. Stop. The pertinent that the petitioner filed an affidavit in reply on 22/5/2024 against the aforesaid affidavit in opposition filed by the contender number 1, whereby the petitioners stated that despite of the aforesaid application filed earlier on 19/3/19, the petitioner submitted his documents through online to the authority along with all relevant records. However,
relevant records on 10 September 20.
the email received is not available with the petitioner. Stop. Paragraph 2 and 3 of the aforesaid affidavit in reply is also reproduced hereunder for ready reference. A to page 21 of Paba, Agor to page 3 of document A. ঠিক আছে? Page 3 পৰা আৰম্ভ নহয়, page 2 পৰা আৰম্ভ হ'ব. Paragraph 62. Stop. In order to constitute the offense of contempt, the essential ingredients is the factum of disobedience, is the factum of disobedience, is the factum of willful disobedience, is the factum of willful disobedience within quotes. Stop. Admittedly, the application dated 19/3/2019 filed by the petitioner pursuant to the order dated 28/2/2018 in WPC case number 5617 of 2018, though is addressed to the State Level Scrutiny Committee, Assam, Scheduled Caste and Scheduled Tribe Dispur, the same has been filed in the Directorate of Welfare of Scheduled Caste Assam, Guwahati. Stop. It appears from the notification dated 11/5/2018 within bracket Annexure 1 to the affidavit in opposition filed by the contender number 1 that the State Level Caste Scrutiny Committee was constituted. Stop. However, the application, stop. It further appears that the direction of this court was to submit the application before the said state level scrutiny committee. Stop. However, it appears from the original application placed before the court that the application was not filed before the state level scrutiny committee but only to the Directorate of, where is that? What is that directorate called?
Scheduled caste. Directorate of Scheduled Caste, Assam.
I had that. Directorate of
Scheduled Caste.
Scheduled Caste,
Assam.
Stop. Therefore, unless and until the application is filed before the committee, the directions issued by this court earlier cannot be undertaken by the committee. Stop. In view of the above, it appears that there is no willful disobedience by or disregard of the by the contemners with the direction given by this court by order dated 28/2/2019 in WPC 6516 of 2018. Stop. As such, no case of contempt is made out. Petition stands dismissed. Sorry. This, Mr. Gaur, this is already on record. That original receipt, shall we keep it or you want it?
My lord, original may be given to me.
No, I think we will have to retain a photocopy.
Yes, yes.
It is there, madam.
A photocopy of the receipt dated 19/3/2019 of the application dated 19/3/2019 is placed before the court, which is marked as X. And the original copy accordingly is returned, disposed of.
Lordship, let the matter be taken after some time. Mr. Esbara is on legs.
Status of bill.
Lordship, we have a fresh set of instructions. We have gotten the approval from Finance Department. Now we have sent the communication to the Accountant General, Lordship. We are moving as fast as possible.
You are appearing for the finance?
For PHE, Lordship. PHE.
Oh, PHE. Who is there for the finance?
Finance is not a party, Lordship.
But you are moving before the finance?
Yes, for the funds, Lordship.
So I'll dispose it of?
Lordship can, if it is...
What is the point of keeping this matter pending? You are said you have already sanctioned, you have moved. So you complete the exercise within the period of 2 months from today?
That can be done. 3 months maybe.
3 months. You want your senior to come or I'll dispose it in your favor?
You can do. As your Lordship wish.
No. You say. Alright. The instruction that you are holding is at 6524.
No, Lordship, this one is...
This is the latest, up to date?
Latest, yes, Lordship.
Up to date?
13.6.
Huh?
13.6, Lordship.
Give a copy. No, but finance is yet to approve.
In the next page, Lordship, it can be seen that finance has approved. Now we have communicated it to the accountant general.
Oh, finance department has no objection.
Lordship.
So finance has objected. Now you have to communicate it to the
accountant general, which also we have done, Lordship.
So then I think
can be closed.
You remind me to write that, the second part of your verbal instruction that. All right. This is also a contempt.
Both same, Lordship. The instruction refers to both the cases, Lordship.
No, they are 25 and 26. They both are contempt cases.
Both.
Then I think it is not right to dispose it. Since it's contempt, you comply it and then we will see. Well, I was under the impression it is a writ petition. It doesn't, you see, because you still have not.
Yes.
Where is the order of this court?
Order
15/2/23. In view of Tamsher Ali. I think it can be because it says dispose it off in terms of Tamsher Ali, and they are doing it.
Lordship, let Mr. Bora come. He'll come, he's on legs.
Alright, wait for something. Yes.
Item 27.
Please,
Who is appearing, Ms. Baudelaire?
Lordship, Lordship would kindly peruse the last order, Lordship. Order dated 10/5/2024.
Yes, a communication.
Yes, Your Lordship. That, Lordship, I have already filed an affidavit as well.
Affidavit, which is the order?
Order dated 10/5/2024.
Yes, Sir Lordship. On this, as per the last order, we filed an IA for implementation of new parties.
Have you done it?
Yes, Sir.
You filed an implementing application?
Yes, Your Lordship.
When?
We filed on 16/5/24, but
I don't
it was
think.
not
Yes,
tagged
Your Lordship,
yes.
it's not there in the record.
Yes, Your Lordship.
All right.
Office note states that no implement
Mr.
A. Hussain, Your Lordship.
A. Hussain, Learned Counsel for the petitioner submits that though an interlocutory application for impleading the new incumbent, to the
not
post.
new incumbent, Your Lordship, the correct incumbent. Because they had implemented the wrong additional deputy commissioner in this contempt case.
For implementing the correct
additional deputy
concerned respondent.
Yes, Your Lordship.
Has been filed, comma, on
16/5/24,
the same is not available on record. Let registry verify and place the same on record. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Yes, Mr. Saikia?
28, Lordship.
Complied? All right. Heard Mr. R.C. Saikia, Learned Counsel for the petitioner. Stop. Also heard Mr. K. Gogoi, Learned. You're appearing as?
For Deputy Commissioner Ayush Garg.
Learned Additional Senior Government Advocate for the respondent number so-and-so, and M.S.R. Bora for respondent number 1 and 2.
I am for 3, Lordship. Ayush Garg.
3, huh? Mr. Mr. R.C. Saikia, Learned Counsel for the petitioner, submits that the order dated, that pending adjudication of the instant contempt petition, the order dated 12/5/2023, passed by this court in WPC number 1162 of 2022, has been complied. Stop. In view of the aforesaid endorsement made by the Learned Counsel for the petitioner, comma, specifically that the order of this court has been complied, comma, this court deems appropriate to close the instant contempt petition. Stop. Ordered accordingly, petition disposed of. Disposed of. Yes.
My Lord, I am on the behalf of the respondent. We need 6 week time for the
your name
for filing.
Your name?
D. Pegu.
MSB Pegu, Learned Counsel for the respondent seeks further 2 weeks time to file the return in the matter.
Pardon, my Lord. 6 week time. 6 weeks time.
3 weeks. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry. It's a contempt matter, so file it within 3 weeks. No further time is going to be given to you.
And we are filing the Wakalanama on behalf of respondent number 3.
All right.
I am paying for respondent. I need 3 weeks time to file a video. I need 3 weeks time.
You will appear for?
For a respondent, my lord.
Sole respondent?
Yes, my lord.
Okay.
The
Mr. S. Borthakur, Learned Counsel for the respondent seeks 3 weeks time to file return in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry. Yes, have you complied? Non-payment of maintenance.
Lordship, I'd like to file an affidavit in opposition also.
None appears for the petitioner on call. Stop. Mr.
Dr. N. Deka.
Dr. N. Deka, Learned Counsel for the respondent. Sole respondent?
Sole respondent.
Respondent seeks 3 weeks time to file the return in the matter. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
Lordship, we have already filed our Bhagavatam, Lordship, 3 weeks time we will plan to file our affidavit.
All right. Your name?
R.S. Rongham.
Lordship, this matter will come up along with the...
Once again, your name?
R.S. Rongham.
Mr. R.S. Rongham, Learned Counsel for the Learned Counsel for the sole respondent. Enters appearance. Entered is the sole respondent is present and seeks 3 weeks time for filing necessary return in the matter. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry along with.
Lordship, this matter will come up along with contempt case number 230 of 2020.
Along with
230.
No, 230 of what?
Contempt same matter.
Along with contempt case C 230 of 2024.
Me, please, Your
Yes,
Lordship.
Ms. Chaudhary.
What is listed before Your Lordship is
an IA.
IA.
Yes.
But that was filed for setting aside the abatement as the applicant was prevented by sufficient reason not to file the substitution petition.
Notice not issued, Ms. Is this come?
No,
I think it has come up for the
Lordship,
first time.
Yes.
So let me issue notice first. Heard MSB Chaudhary, Learned Counsel for the petition for the applicant. Stop. This is an application under Order 22, Rule 9 of CPC 1908 for setting aside the abatement in the present contempt petition. Stop. Issue notice, returnable 3 weeks. Stop. Registered steps by registered AD within a period of 2 days from today. List after so and so on a date to be fixed by the registry.
My Lord, there is another application, but
Yes.
that's not on record. It was filed together at that point of time
then
for
in-
substitution. IA 1948.
1 second. That is not on record.
That is not on record.
Should I say list along with?
Yes.
List. It is further submitted that IA Civil 1948 of 2024 is not listed, which is also filed in contempt case C 485 of 2020 is not listed before this court today. Stop. Accordingly, list the said IA so and so also on so and so.
Great. Much obliged.
Mr. Chalya, you are appearing in
Yes,
this?
Lordship, I am appearing for respondent number 6. We have filed an affidavit, Lordship.
In the contempt?
Yes, Lordship.
No, but there is an IA for abatement.
Yes, Lordship.
You appear for one of the respondent?
Yes,
the
Lordship.
abatement
Respondent
proceedings?
number 6.
6.
You have received a copy of the IA?
Yes, Lordship, I have.
In case of respondent number 6, you say, Mr. A. Chalya, Learned Counsel, appears on behalf of R6. Stop. Extra copies within the course of 2 days from today, and rest registered post-haste.
Otherwise, we have complied with the court's order. We have complied with the court's order. Otherwise, if
anyway, the contempt is not today. Let notice go.
Much obliged.
In the meantime, Ms. Chaudhary, he says it has been complied, so you obtain your instructions.
No, Lordship. That compliance is not.
All right.
Great.
This is that matter.
My lord.
Yes.
Had it been, my lord, with all respect, my lord, yes, 173(8) is a must, my lord. Notice has to go. That is the mandate of the court, my lord. Here, my lord, what has happened, my lord, this stage, when we file the application, my lord, first of all, my lord, when investigation is carried out in a tardy manner, my lord, not in a proper manner, my lord, in that event, my lord, the first court of action, my lord, whichever is to be taken up from the petitioner's side, my lord, that is that Sarkari Bosu authority, my lord. We have to file application before the Chief Judicial Magistrate under section 156(3), my lord. Several applications were filed, my lord. There were 9 investigating officers changed, my lord. And the subject matter is 63 lakhs of rupees, my lord. Loan was obtained, and that too fraudulently, my lord. My DRT proceedings are pending, my lord. And thereafter, my lord, one investigating officer, unfortunately, he expired, my lord. Along with him, my lord, the CD evaporated, my lord.
Do you have any authority on setting aside of closure reports by?
Yes, my lord. It is, my lord, in either form because FF takes into account, my lord, with all respect, my lord, charge sheet also, that exact paragraph I am reading out, my lord. With all respect, my lord. Because taking recourse to 173(8) by filing Naraji before the Lanet Court below, my lord, would be, my lord, going back again 10 years backwards, my lord. Because same step we took at that point of time, my lord. Despite the direction for construction of the case diary, it was not done. The basic, my lord, courtesy of investigation, my lord, in a case like bank fraud case, my lord, none of the bank officials were pretty simple, possibly, my lord. The manager who sanctioned the loan at that particular point of time, he should have been taken. I'm not saying taken into custody. I'm not saying that, my lord.
Statement.
Exactly. He has to be brought under my scanner, my lord. It was not done, my lord. And, my lord, the authority is there. There are several authorities, my lord. When, my lord, with all respect, my lord, even if charge sheet is filed, even if trial is continuing, even in that event, I'm not saying that it should go to...
That is different.
No.
But here, in your case, the closure report was filed.
One closure report specific case is there. Yes, my lord.
And closure report is filed because nothing was found.
And, my lord, that too by an probationary officer, my lord. Bank fraud cases, my lord, cannot be handled by probationary officer. It has been submitted by, that is a different angle, my lord, Sub-Inspector of Police Probationer, my lord. That is, my lord.
But this Bela Trivedi, Justice Bela Trivedi and Justice Datta's decision you had submitted on the last occasion?
No, that state has provided, my lord.
Because this says, on the receipt of police report under section 173, the magistrate can exercise 3 options.
Yes, my lord.
Firstly, he may decide that there is no sufficient ground for proceeding further and drop action, which has been done in your case.
Yes, my lord.
Secondly, he may then second and third we are not concerned.
My lord.
Even in a case where the final report of the police under section 173 is accepted and the accused persons are discharged, the magistrate has the power
My lord.
to take cognizance of the offence on a complaint or a protest petition on the same or similar allegation, even after the acceptance of the final report.
Lordship is correct.
Magistrate is not debarred from taking cognizance of a complaint merely on the ground that earlier he had declined to take cognizance of the police report. Magistrate, while exercising his judicial discretion, has to apply his mind to the contents of the protest petition or the complaint as may be.
My lord.
Now, in this case, you have not protested, you have not filed anything before the magistrate.
Can I place it in this manner, my lord?
No, because you see, you
Yes,
are
yes.
before a 226.
Yes, yes.
Writ. You are before the writ court.
Yes.
Alternative efficacious remedy appears to be available to you,
Yes, ma'am.
which you have not taken recourse to. Now, in view of the availability of the alternative remedy, should this court at this stage exercise the discretionary equitable power that this court
right
has?
query, and Lordship is very correct, my lord. Can I place it in this manner, my lord? Can I place the
Yes,
first
yes.
the factual metrics, then the law, my lord? Factual metrics is this, my lord, so that the case can be brought or given to some other agency, my lord. We filed this application 10 years back, my lord. At a point of time, we resorted to Sarkari Bosu, my lord, meaning thereby went to the learned magistrate under section 156(3). Lot of applications were filed. Then the case diary went missing. It was directed to be reconstructed. Even court called for the case diary. That was not placed before the court, my lord. Thereafter, my lord, this case was continuing, my lord. And regarding factual metrics, my lord, two
Mr.
reports.
Mahajan, at the time you filed this writ petition, that closure report has not come.
No, closure
That
report
came
is right now.
subsequently.
At the end of the day, my lord, in 24.
So then now you can go and file
Then
a
it
protest
would be, my
petition.
lord. Can it be like this, my lord? I'll place an authority also in a given situation like
Yes,
this,
yes,
my lord.
yes.
Prior to that, my lord, it would be making the same rounds again and again, my lord. Because I complained 10 years back, well, not complained, my lord, whatever be it, my lord. I came up before your lordships, my lord, by following the due process of law, that is Sarkari Bosu, my lord. Thereafter, my lord, after 10 years, change of that, the last report says, my lord, with all respect, my lord, 9 investigating officers were changed. Diary was directed to be reconstructed, possibly not reconstructed because it even never came
The
to the court.
magistrate will look into it.
My lord, can I just place
You
it?
see, this is not, Mr. Mahajan,
Lordship is correct.
the orders to transfer it to CIDs or CBIs cannot be as a matter of course
Yes,
be
yes,
given, right?
yes, yes.
An exceptional situation has
Yes.
to be placed before this court. Now here it appears that the investigation is done and ultimately a closure report has been issued. Now, if you're not satisfied with the closure report, you have your remedies available in law.
Can I
you
just
can take recourse to.
Lordship is correct, my lord. Can I just place it in
Yes.
this manner, my lord? Because it will be myself going back 10 years backwards, my lord. And second thing, my lord, in a given situation like this, my lord, one authority says when closure report was submitted, because, my lord, I'll read the authority, my lord.
Yes,
Prior
yes.
to that, the factual metrics, 63 lakhs defalcated. The police definitely, I should not say, my lord, possibly hand in glove. Otherwise, my lord, no banker was brought to under scanner, my lord.
See, these, whatever you are saying, are grounds which you can say you
Before
can,
the learned magistrate.
In
Then
your
it would be
protest
the, my lord,
petition.
then that Sarkari Bosu application, the same stage would come, my lord. Nothing happened, my lord. And now can I place this authority, my lord, with all respect, my lord. When closure report was submitted, even in that event, my lord, it was handed over to some other agency, my lord.
You see, these are, as I said, this is a discretionary.
Yes, yes.
Remedy,
very much,
right?
my lord.
So it will depend on the
Possibly
context
it
of
will
each
be a
case.
situation, my lord, with all respect, my lord, where, my lord, 63 lakhs defalcated, 10 years of investigation, my lord, and, my lord, at the suddenly, my lord, in a jiffy final report, 2 reports I'll be placing before your lordships, what materials then found, my lord. Can I please just...
See, even in Sarkari Vasu, it has been said, even if an FIR has been registered and even if police has made the investigation or is actually making investigation, which the aggrieved person feels is not proper,
Yes.
such a person can approach the magistrate under section 156(3).
We did that, my lord.
And
We did that.
And if magistrate is satisfied, he can order a proper investigation.
Exactly.
So this you had done.
This we
And
we
it-
did
Huh.
to the best of our ability. The learned court tried its level-based, my lord, because certain things happened, my lord. CD went missing, my lord. Definitely bankers were hand in glove. Possibly, I should not say that, my lord. And thereafter, my lord, in that given situation, ultimately whatever CD was directed to be reconstructed, it was sought for by the court, it was not placed before the court. And thereafter, my lord, I'm placing these orders, my lord, how they investigated, my lord. And my lord, so far as the law is concerned, my lord, even when closure report is there, my lord, despite this, my lord, with all respect, my lord, filing of Naraji, despite that, my lord, Apex Court has, my lord, with all respect, my lord, elaborately quoted on this point that when it was submitted before the Apex Court, my lord, that FF, my lord, because the investigation was directed to be carried out within a time-bound period, my lord. Okay, if I read that, my lord,
yes.
Can I
Yes,
can
please.
I just?
Yes, please. I'm hearing you.
I'm
Take
sorry.
your time.
My lord.
There is no rush.
Yes.
I
My
think
lord.
I've almost finished my board.
My lord. This is, my lord, with all respect, my lord. I'm pressing it, my lord. No, I'm taking a minute, my lord. Judgment of Kakos Kundus. Closure report. I'm taking a minute, my lord. Judgment of Kakos Kundus. I'm just taking a minute, my lord. My fan has missed.
In these documents, Mr. Mahajan,
my lord,
there appears to be some communications which had been earlier placed before this court,
my lord,
and this has been kept on record and marked as X.
My lord.
Now, from here, it appears that the investigation officer has also contacted with the UCO Bank officials,
my lord,
and has collected documents.
My lord, that part, my lord, they collected the bank documents, my lord, whereby loan was given.
And
That was obtained from the DRT, my lord. Kindly see, my lord. And my lord, the original documents, those are to be there with the bank, my lord. Even that was not looked into, my lord. Because here is a
All
case.
right, you want to show something?
Yes, my lord. Yes, my lord. I'm taking a minute, my lord. With all respect, my lord. So, here can I listen to judgment.
Mr. Nair, Mr. Borthakur, which are your matters? Mr. Borthakur, I think that criminal question.
Yes.
And yours?
Cat land matter, my lord.
That's a hearing matter.
Yes.
My lord, this is, my lord, with all respect, my lord. I'm taking a minute, my lord. In appropriate cases. Lordship would kindly have a look, my lord, with all respect, my lord. This authority, I am placing it before your lordship. Come say. Asa, how will I get? I'm reading it and placing it before your lordship, my lord.
Yes.
With all respect, my lord. Herein, my lord, with all respect, my lord. There it occurs at para 47, my lord. I'm reading the relevant part, my
This is
lord.
a decision of?
My lord, with all respect, Anand Thakur Kamse was a state of Maharashtra. He made 24.
Of the Apex Court?
Apex Court, my lord. Because
Ms. Das, this is Anand Thanur Karmose versus State of Maharashtra.
my lord. There it occurs at para 47, my lord.
Para 47.
Para 47, my lord.
There is no para 47.
Yes, peculiarly marked, my lord. 2.3, it goes on and on.
Oh, this is a quoted portion.
Yes, my lord. Para quoted portion chronologically 47, my lord.
Yes, got it. The extraordinary power.
Actually, it goes on and on, my lord.
Yes.
Thereafter, if I intend to turn the page, my lord, from the last line of para 47, my lord,
Yes.
we are conscious of the fact, though a satisfaction of one crop.
One sec. Where is this line? Yes. All right. Please read.
My lord, with all respect, my lord, we are conscious of the fact that though a satisfaction of want of proper, fair and impartial and effective investigation, eroding its credence and reliability, is the precondition for a direction for further investigation or re-investigation. submission of charge sheet ipso facto of the pendency of the trial can by no means be a prohibitive impediment. In the same language it goes on and on, my lord. Even if, here the reverse, my lord, if charge sheet is filed, even some lapses are found, even in that even it can be given. Here is a case wherein out of the blue, my lord, despite pendency of the application, my lord, with all respect, my lord, pendency of this application for 10 years, my lord, without informing the court, that is another aspect, my lord, they file final report, my lord, with all respect, my lord.
What kind of allegations have you leveled in the petition?
My lord,
what are your apprehensions that affair?
No, my lord, I came to know about it from the DRT notice. Prior to that, I am residing there, my house. It was loaned out, my lord, mortgage, and thereafter loan was obtained to the tune of 63 lakhs. That application, my application is pending before the, because of a high court stay pending before the DRT, my lord. But the criminal part of it, crime never dies, my lord. So many authorities are there, my lord. And they have carried it out in a manner, my lord. First, unfortunately, one investigating officer was dead. Thereafter, my lord, the CD evaporated, my lord. Case diary evaporated, my lord.
Where do I find these paragraphs?
Exactly, my lord.
How many IOs changed? 9.
Yes, last report, my lord. Can I just place it before your lordship?
Yes, IOs, and then you said CD was lost.
My lord.
CD was reconstructed or lost.
It was not found, my lord. So by that Sarkari Bosu applications, my lord, Blaned lower court below directed the IO to reconstruct it, my lord.
There is an order.
Yes.
Page 42.
Page 42 of the application, my lord.
It's 42.
Of the writ petition, my lord. We annexed that, my lord.
After reconstructing, they did investigation and then ultimately closed.
Exactly, whether reconstructed.
But let us take it in that manner, because at the end of the day, there is an order of the magistrate to reconstruct it, and the investigation was ultimately taken to the logical conclusion by submitting a FR.
Yes.
Correct?
Yes.
Now where? Page 42?
42, my lord.
In 2015 only?
Yes.
Closer report is of?
2024.
Why so much time was taken, Ms. Das? What is the explanation? No, but I think, you see, no doubt that the remedy before the magistrate is open, but nonetheless, this has been brought to the notice of a constitutional court merely because closer report is there. This court may not just leave it here, isn't it?
Yes,
because at the end of the day, this is a equitable court. Now it appears 24 years has been taken to finally submit a closure report. What happened during the intervening period?
That is
I think some explanation is required. Otherwise, you see, by relying on the apex court decisions, this court can simply send it back. But would real justice be served? Because this person, this case is pending for quite a long time.
Yes, madam, but since Lordship, this trial court's orders are also there, my lord, because CD again, my lord, it was could not find out and all.
Correct. Ultimately, 16/5/15 order.
Now, my lord,
it was reconstructed. What happened thereafter for 24 years?
Reconstruction was probably 2015, madam. 2015.
The order is of 2015, but what happened after 2015? The closure report is of 20?
My lord,
24.
My lord, record I have found in my noting in the file, my lord, record and case diary received in original and returned, my lord. Probably it was placed before the court, my lord, probably. The CD.
That is all right.
But beyond CD, my lord, If your Lordship direct me to produce this, my Lord, because probably already everything has been submitted before court. So, my Lord, second copy, they may have been having, my Lord, their copy. So, if your Lordship direct me, then I can produce it, my Lord.
Produce the case diary.
Case diary, because
I
photocopy
think we
they
can
keep
direct
with
that, Mr.
Yes,
Mahajan.
yes.
Let us have a look before we
photocopy, yes,
make
ma'am.
our final,
Lordship is
we
correct.
come to a final
Correct,
conclusion.
my lord. Correct, my lord. Correct.
Rakhe to Dada, second copy and the photocopy.
Duplicate case diary, my lord, because SR
Probably
case.
that is kept in the.
Alright, Sharmila. Heard Mr. B.M. Mahajan, Learned Counsel for the petitioner. Stop. Also heard M.S.U. Das, Learned Additional Senior Government Advocate for the state respondent. Stop. During the course of the hearing, comma, it appears that the case diary is required to be perused specifically to find out as why the final closure report was submitted after almost
10 years of filing the application.
10 years of filing the application.
My lord, my lord.
10
my
years
lord.
of filing the application.
My lord.
Stop.
Okay.
Let second copy or
Sorry,
duplicate?
9 years.
9 years.
9 years,
9 years.
15 to 24.
Second copy or
Duplicate copy. My
Duplicate?
learned senior
Yes,
friend.
yes.
So
Mr.
far as the
Mahajan,
police-
please enlighten.
Police keep, yes,
Possibly,
ma'am.
my lord, in SR cases, my lord, specially said 3 diaries are made, my lord, as per
Correct,
the
correct,
Assam
correct,
Police
correct,
Manual.
correct. Manual,
So
yes.
one has to remain with the circle officer, whatever be it, my lord. It can be sought for, my lord.
So I will say duplicate copy or second.
Possibly it is, my lord. Or lordship may not quote that, my lord. Where the case diary be placed before the court, my lord. That
My
would be
lord, in any form. My
Yes,
Case diary either in
up to date, my lord.
Huh?
Up to date case diary.
up to date case diary, either in the form of duplicate.
My lord.
No,
That-
duplicate
that-
is a very negative word.
Yes.
That may not
Either
be,
in
my
the
lord.
form of second or third copy.
Can it be,
Maintained
my
by-
lord, I may be wrong, my
Yes,
lord.
yes.
Only, my lord, case that would suffice.
Case diary.
Because I don't want on the next date Ms. Das to come and say, or somebody else from the government to come and say कि case diary is before
Already
the court.
submitted. Yes,
so-
my lord. That's
only
right.
for that purpose.
Oh,
Yes.
my,
And or otherwise, I'll be asked then why you have
Okay,
not informed
okay.
the court that has already been
Case
submitted.
diary
in any form,
in
my lord.
any form as permitted under the
Law.
under the applicable under the police manual
Exactly.
shall be placed before this court on the next date of listing by the government,
My
by
lord.
the state, by the learned council appearing on behalf of the state
My
respondent.
lord.
Stop. List on
Any day, my lord.
My lord,
Any
last
day.
week of my lord, July.
Give a date.
Last July. Last week of July.
Hobo.
32, my lord.
Hobo. My lord, my lord. My lord, highly obliged, my lord. Can it be, should I say or not, my lord? Can it be part lordship as heard it, my lord?
let it come.
My lord, my lord, my lord.
Mr. Chaudhary, Mr. Chaudhary, in your matters,
Yes.
To be honest, I did not have much time, though I had the case diary, but I did not get much time to go into it. So,
Some other day, my lord.
yes, when do you want it?
After vacation, my lord.
After vacation, at that date did you go? Item number 37, right?
Yes.
No, no, 38.
38.
Item
48.
No. Criminal. 38, correct?
38.
In item 38.
On 23rd, my lord, it's a Tuesday.
Hearing remains inconclusive. List again on
23rd of July, my lord.
23/7/2024 for further hearing.
Dibru.
Mr. Ganguly, the 3 decisions that you had you're relying upon are also on the for whether mandamus would lie
Yes.
against are on that.
Are
But have you found any decision which is about the clubbing of the 2 prayers? Because suppose this court comes to a finding. So I'm saying hypothetically that this court comes to a finding that the first prayer is not maintainable. A mandamus cannot be issued against a bank. Be it as it may, the second prayer is against the state for a non-action. That this court can always, if there are, if the court comes to a finding that yes, the state has not acted in a manner that the state is required to act, then this court can always pass an order. So on that basis, this court cannot say the entire writ petition is not maintainable.
I was actually, my lord, that is why I was drawing the analogy of the rejection of plain petitions.
Correct.
Where a plaint is ordinarily not rejected.
You see, therefore, in that situation, what will happen is that this court cannot grant you the mandamus as regards your prayer A to the bank. But I remembered you had said the state, the revenue also cannot do anything now because...
That was what the revenue had...
What was that submission?
They said that unless it is corrected from our end, they cannot proceed with the registration.
They have put this on any record?
The affidavit has not been filed by the state.
I think Mr. Gogoi had it.
Yes, Mr. Gogoi had it. State.
We received in the 2018 some instruction.
Yes. What is that instruction?
Instruction says, what my learned brother...
Please give it then.
Lordship.
See, if we see prayer number 1 is to direct respondent number 4. Now, who is 4? 4 must be the APDCL? HDFC Bank, sorry.
Yes.
HDFC. 4 is HDFC. So that perhaps, okay. Now 2 is 3 and 1, 2, 3 and 5. And these are the state authorities, correct? Correct. So for 1, 2 and 5, that direct the respondent 1 to 5 that the requirement of obtaining NOC under section 21 of so-and-so shall not be insisted upon in the case of so-and-so. This prayer can always be gone into. Subsequently, prayer number 3. So as a whole, I don't think this is a case where this court will go with you, Mr. Pathak, and say the entire repetition is not maintained.
I think the only difficulty that, as I see it, and perhaps my learned friend would also agree, would be, Malas, that the state would be is that we are unable to register the sales certificate. We would be unable to register the sales certificate, and also the consequential measures, Malas, for example, mutation, etc. Because
unless
the sales certificate, because the sales certificate.
That is where the difficulty lies, because
the reliefs are, Malas.
Maybe the district court could have been a better remedy, perhaps, in such a situation.
District court,
perhaps, I don't know.
Look, the difficulty would be, before, as far as the civil court is concerned, the moment they see a matter under the Surface Act, they would summarily throw out my suit.
Just 1 second. Their stand is very clear, but that they cannot give you the NOC because the land remains only 2 bighas.
Yes. And the sales certificate is 2 bigha, 3 kata, like that. 9 lessons. That is the issue.
Actually short by 3 kata 9 lechas.
Yes.
And co-owners of land did not file their no objection as the property is joint property.
Yes. Now that, to insist upon that, in these circumstances when there is an auction conducted.
Why this has not been filed by way of an affidavit? Would it be not proper that you file an affidavit and have your stand clear? No, but an affidavit should have been filed. Because a lot of things have been said here. Now, I don't want to give any comments as regards the first prayer, because since if I keep this matter pending, then it will unnecessarily prejudice. So let me then make it clear that it appears that the stand of the state respondent is essential, and since the pairwise comments are there, let them place it by way of an affidavit.
At the same time, let me also try to look out for any instance where a composite
you find out.
relief.
You see, no, there is no difficulty. Like tomorrow, you never know. This matter it will all depend on where this matter travels from which court to which court. But otherwise, according to me, prayer number 1, this court cannot grant. Because a mandamus would not lie against a bank. That decision on bank is very clear. And I can distinguish the other decisions which you have cited. There is no difficulty. However, saying so, I am not going to dismiss this writ petition.
Yes.
Because prayer number 2 and prayer number 3 appears to be against state officials for their non-action, whatever reason ABC may be. But that has to be looked on in the merit of the contention, right? That cannot be dismissed.
Yes.
He has a right against to come up against the state. So now to examine that, the stand of the state is important.
Yes.
How can this court examine that stand?
Yes.
Now if I go for all this detailed order, then perhaps it may prejudice the... I don't want to do this because since...
then the state must be maybe directed to...
That's right. I'll say that that matter was taken up for hearing. However, during the course it appears a stand is required and we'll give them time. Alright?
Gotcha.
That would be more appropriate.
Perhaps a little peremptory nature of an order might be possible, considering 6 years have passed. Slightly peremptory.
No, you see, I can dismiss the first, I can deal with the first argument and limit the matter to the second relief, if you want. Do you want me to do that?
I'm not saying, Lordship will keep it open, but I'm saying
otherwise,
that let them file their affidavit.
You want a specific time?
Not for them, I'm saying the state.
That I can.
My lord, this letter is, my lord, I think it's Tezpur Development Authority. Tezpur Development Authority has given this instruction to the director, Town and Country Planning. It's an instruction of, my lord, Tezpur Development Authority.
But now, my lord,
who's appearing for Tezpur Development Authority?
They have not appeared, my lord, and in any case, now, my lord, as far as the town area is concerned, TDA will not have the authority. It will be the municipal board which will have.
It is not the instruction from the state, my lord. I'll have to obtain instruction from the state.
Well, I think it would be better for the deputy commissioner, perhaps, or the revenue.
No, there is no difficulty, Ms. Das. This court will give you the time.
My lord, because I'll have to take instruction. It's not the instruction from the
It part. Head court thought asilani. Heard Mr. A. Ganguly, Learned Counsel for the petitioner. Also heard Mr. K.P. Pathak, Learned Counsel for respondent number 4, and M.S. Udas, Learned Additional Senior Government Advocate for the state respondent. Stop. None appears for respondent number
3.
3. That authority. None appears for respondent number 3. Stop. Notice and everything was served?
Yes.
This matter was taken up for hearing on 13/6. On 13/6/2024, and was fixed thereafter today for conclusion of the hearing. Stop. However, during the course of hearing, this court is, however, after hearing the parties partly, this court is of the considered view that in order to effectively decide the issue arising out in the instant writ petition, specifically with regard to prayer number 2 and 3, the stand of the state respondents, particularly respondent number
2 and 5.
2 and 5 shall have to be gone into. Stop. M.S. Udas, Learned Additional Senior Government Advocate, seeks 3 weeks' time to obtain instruction and file an affidavit in opposition in the matter to bring on record the stand of the district administration in relation to the prayer sought for in this writ petition. Stop. As such, next paragraph. As such, the matter is released from Parthurt list this matter after 3. Do you want a date? The whole matter. List on such and such date. Stop. Next para. Needless to clarify that since the issue involved in this matter pertains to the year 2018, the state respondent shall act expeditiously and furnish the requisite instructions as sought for by and place the requisite instructions to enable the additional senior government advocate to file the necessary affidavit in the matter. Stop. All right. Date
5th August. 5th of August.
Ms. Das, you take back these.
5th.
Please try to have the affidavit before that. Mr. Ganguly, I think you can have this back because it might go lost in the file. So you keep it, if required, you give it on the next date.
5th of August.
Deeply appreciated. Yes, yes. There is more set of information that you have given on as regards mutation and all. Do you want these back?
Lordship, let it be a part of it. No difference.
Have it. तो पार्थड भी लिखा नहीं CD2 पार्थड लिखा नहीं এটা কোয়াই দিব পাर्थड Mr. Chaudhary, that matter appears is not kept as parthard, that criminal that repetition. So I've asked him to keep it as parthard because otherwise what happens, the CD is available.
Yes.
And
It's parthard.
if it is sent to it doesn't look appropriate if I send it back to the bench.
Remain as part.
Item 25,
Yes.
It was the last two order on, it was on 1/4/2024. My friend has said that a supplement demand has been made. Thereafter on 22/5, said this amount should be come on another a different head. That head is being prepared, my lord. There is some accounts department, there is AG, there is some objection that formality is being carried out.
So what is to be done?
My lord, think that only that amount that is due
Has not been paid.
Contractual, that had to be paid.
So let's keep it pending then, because if I dispose it off now, otherwise I was almost about to dispose it off in the direction that it is progressing, but still you have not received.
We have not received. Lord will fix it after vacation. In the meantime, they should work out on the...
Mr. I. Borthakur, Learned Counsel for Respondent number 1 submits that the matter is progressing substantially in order to release the outstanding contractual bill to the petitioner. Stop. In view of the aforesaid endorsement made by the Learned Counsel for the respondent, let this matter be listed again after 3 weeks on a date to be fixed by the registry. Stop. You have it, whatever is to be done before that, because you see, contempt doesn't mean the jurisdiction of contempt is not for execution of the orders passed by this court. So please keep that in mind. If by next date nothing is done, this court may think otherwise, because then you might have to explain.
So we are doing our best.
You do your best. That is why this court at this time is giving you. But nonetheless, contempt should not be made a tool for getting the orders of this court executed. You should have complied with the order of this court at the first instance. Correct? So please do whatever is to be done before the next date.
Lordship, can I have the copy of that communication?
It will
Okay. Item 26, same order.
25 and 26. 40. Yes, what is this?
Lordship, this land was acquired by the SP Kasar way back in 1973, and the petitioners have been since long filing representation for compensation. It is their own private land, and till then nothing has been paid.
Nothing has been paid?
Nothing has been paid.
This has been acquired?
Acquired, yes.
And show me the document under which it has
Nothing
been...
is there, only they have, upon my various inquiries, they have just issued an letter number being KCS/8/.
No, that letter is not on record.
That's not. I have filed RTI to get that letter. It's nowhere available, Your Lordship.
And where do we get that admittedly the land is in the possession of the state authorities?
Now, what they have submitted in their affidavit, that they verbally, my father have verbally donated that land.
Okay.
But
so the factum of possession is admitted?
Yes, Your Lordship. But at the
where in the affidavit?
Para 4, page number 2, Your Lordship. It's affidavit in opposition filed by the respondent.
R4?
Number 4. Yes.
R4?
R4, Your Lordship.
Yes, page?
Page 2, para number 4.
Para number 4?
Yes, in this regard, the statement made in...
No, I think I am... Is a counter affidavit filed?
No. Affidavit in opposition filed by respondent number 4.
Okay. Para number 4. Yes. Please read.
In this regard, the statement made in paragraph 3 and 4 of the writ petition, deponents state that in the year 1973, the land of Rajatila Police Outpost under Katigora Police Station, District Kasar, Assam, measuring 12 Katha 2 chalk covered by 2nd RS Patta number 139 and Dag number 347 of Moja Nazi Hajinagar, Pargana, Hari Katak was donated voluntarily by one Keramat Ali Borguya, the late father of the petitioner, on verbal agreement for construction setting up a police watch post titled Rajatila Police Watch Post on the aforementioned plot of land. Subsequently, the Rajatila watch post was constructed by the department on the said land, and since there was
verbal donation, Ms. Das?
Lordship. Verbal donation, and my lord.
What about compliance? What about Article 300 capital A?
Lordship, page 10 also.
What about his constitutional basic human right?
Page 10 also says, my lord, that his son was, my lord, it was donated on the, my lord, that page 4, paragraph 10. My lord, second paragraph. However, the petitioner submitted a petition dated 6/12/2010 for appointment of his son in the department, which was duly forwarded from the office to the Inspector General of Police, Assam, Guwahati, by this letter dated 6/1/2011. Again on 6/3/2013, the petitioner submitted another petition for appointment of his son in the department, which was also duly forwarded to the Additional Director General of Police, Guwahati, such and such.
That can't be.
Lordship,
ultimately he failed also. He is not appointed.
That is different. We are basically...
Admittedly, it appears that the land is in possession of the government since 1976. Either you come up with some positive instruction or this court shall direct that you verify and you give compensation. I think that would be most appropriate because...
Lordship, this is the municipal Kolkata
Yes,
municipal.
yes. Kolkata municipal and that Tukaram's case.
Yes, Your Lordship.
Right to property may not be a fundamental right, but it is constitutional, statutory and basic human right of the petitioner.
Unless any due procedure is followed, that...
procedure has to be followed, madam.
Absolutely, and it appears has not been followed. Verbal donation.
Nothing is there on record, Your Lordship, to show. What the Supreme Court has observed, your non-compliance of this will amount to the violation of rights being the authority of law, Your Lordship.
Lordship, may I take let it be, my Lordship, maybe please to take up, my Lord, immediately after vacation, my Lord.
No, not immediate after vacation. I can give you time till Thursday if you want. This matter cannot be kept pending like this. It's a very short matter. If you do not come up with anything positive, I am disposing of this matter, directing the state government to compensate the petitioner. It cannot be kept pending like this. Since 76, you have been deprived the petitioner his right over the land without following the due procedure of law.
Lordship, land cannot be acquired like this, my Lord. Maybe on Thursday, my Lord.
Thursday?
My Lord.
List for further hearing on Thursday, I say.
Lordship.
I will make this part heard.
Yes, I have filed an application for amendment of the writ petition law because respondent number L10 and 11 have been implemented on the last occasion. And there are certain issues.
I thought implement was already allowed, not allowed.
Yes, it was allowed on the last occasion.
Yes.
Therefore, I have prayed for amendment of the writ petition because certain amendments have been brought to record. So very relevant.
Amendment of the? Amendment of the?
Writ petition.
You are the petitioner.
I am the petitioner.
So you filed an IA for amendment?
IA, my lord. That is, my lord, just from today, my lord. Just filed today, my lord.
IA, sir. Mr. Chaudhary, you have received a copy of the IA?
No, my lord. Huh? No, my lord. Before my learned, actually what had happened, my lord, my learned friend represents a governing body of a particular school. Now what had happened, X plot of land was given to the school, allotted. Now they never paid any premium and
This
all.
is for that cat building?
Yes. Then what happened, my lord, that was slightly bigger area. So they have not utilized the land for the purpose for which it was given. And under the government instructions issued by Revenue Department, if particular land is not used for the purpose for which it is given, then the land revests in the government. Be that as it may, what government did, X plot of land was given to CAT.
That remaining part of the entire part?
And no, another plot of land of 1 bigha was given to them. 4 kata 10 lakhs.
No, the total land initially given to them
was more or less 2 bigha.
2 bighas?
Yes.
And they did not
apparently that land now has been, because they have not utilized
it for the purpose that it
for
was
it,
given.
that land has been given to CAT.
Well, that is not factually correct.
Wait, Mr. Datta. Yes.
CAT. Yes. Now, my lord, the successor governing body of the school has accepted the reduced land which has been given to the school.
Thereafter, but then this is not clear because you said 2 bigha has been given to the school
initially. They
and,
have not,
and thereafter, because they did not utilize, 2 bigha has been given to CAT.
No, that 2 bigha of land, 1 bigha has been given
out of 2 bigha,
yes.
1 bigha has been given to CAT and 1 bigha was with the school.
2 bigha, 1 kata was given to the school.
2 bigha?
1 kata.
1 kata.
In 1982.
Now the end result is they are having 1 bigha more or less. We are having 2 bigha more or less.
How come it became increased?
No, because they did not utilize the land for the purpose which was given. That government gave the land to us.
Mr. Chaudhary, sorry.
Total 3 bigha.
That's right.
Total 3 bigha.
Total land is 3 bigha.
Dugs are different, Melon. Dugs are different, Melon.
Maybe, but I'm
So,
just
yes,
trying to
yes,
understand.
yes.
So out of 3 bigha, now some portion has been given to CAT and some portion remained with you.
Now, my lord,
now what happened?
Now what had happened? The successor managing committee has accepted the land which has been now given to the school.
Now the new members
now they filed a suit regarding this dispute.
Which one? The new?
They. Now the suit was withdrawn without any liberty. I do not know how this writ petition is maintaining.
I'll satisfy that.
Secondly, my lord, now initially there was an order of status quo. Now if your lordships would kindly have the order dated 18/7/22, that order of status quo was...
The writ petition is filed by them.
Yes.
And order is
18/7/22. This order was modified.
Just a minute.
Yes.
First order appears to be 6522.
Yes, there was an order of status quo. Then please come to 18722.
18722. Yes.
Please come to the first para of the order.
Yes.
This court-wide order dated 6/5/22, while issuing notice of motion, had made the following observation. Considering the above, as the land involved in the case has already been handed over by the Circle Officer, Guwahati Revenue Circle, to the respondent number 6, that is CAT, on 11/3/22 itself, and respondent number 6 is already in possession of the said land, parties to this proceeding shall maintain status quo as on today with regard to possession of the said land. Pendency of this writ petition shall not be a bar for the respondent number 5 to finalize and proceed with the tender process for construction of court-cum-office building of Central Administrative Tribunal, Guwahati Bench, over the land involved in the case in terms of tender number so and so. Sri A.K. Behra, Learned Senior Counsel, assisted by Mr. S.K. Ghosh, Learned Counsel for the CAT bench, submits that though the order dated 6/5/22 is clear order, only because of the expression maintenance of status quo, some confusion may arise while going ahead with further developmental activity on the plot of land in question. On the other hand, Dr. Learned Counsel submits that there are sufficient merits and grounds in making the present challenge and no further clarification is necessary. After hearing the parties, it is made clear there is no kind of any restraint put by this court in its order dated 6/5/22. In other words, respondent number 6 is free to go ahead with any developmental activity over the plot of land. It is, however, needless to mention that all such activities will be subject to outcome of this writ petition. Accordingly, so this was the order, my lord. Now, as a result of this, the construction is complete. Now, the building which is supposed to premise, my lord, both the court as well as the office is ready for inauguration. Because of the pendency of this honorable proceedings, my lord, the authorities are not in a position to go ahead with it. Now, my lord, the most important aspect in this case is the earlier governing body who...
Before we go to that aspect,
yes.
Why is this matter today? Because you see, as far as this order is concerned, this order is absolutely clear.
Yes.
That you go ahead, do whatever you want. Only thing, it will remain subject to the outcome of the writ petition.
Yes.
Correct? This is the only thing. Now, because of that, the authorities are...
Yes.
But the building
Since
is
the
already ready.
Since the proceeding is pending,
So
and that is also
you
a
are
tribunal...
seeking a disposal of the writ petition?
Yes, because I will satisfy your lordship, the petitioner number one
No,
is...
but and all these IAs, there is no IA as regards any modification or anything, right? You are...
No, I am not saying... We are seeking disposal of this proceeding.
Seeking disposal. Now, there the only difficulty comes is that...
No, because the party which has been implemented, my lord.
Now, since you have not
first there was a suit.
No, Mr. Chaudhary, just...
I'll come to that, my lord.
Since you have not objected to the implement of the
No, I have not.
party, correct? Now, today they have filed an application seeking some
No.
amendment.
What they are doing, my lord,
Yes.
they want to challenge that resolution of that school whereby the new committee was made.
No, my lord.
That's what they are challenging.
No, my lord. What I'm challenging is the handing over of the land, my lord, to a committee, just fake committee, my lord. I'll show that, my lord. It has got no locus, my lord, to
My
come
lord,
in.
is it a civil proceeding that my lord, learned friend wants to prove that this committee is right, that committee is wrong?
I will show from the
My lord,
records, my
this
lord.
gentleman,
They have got no right at all, my lord.
Councillors, please speak in your own turn. Mr. Datta, please take your seat right now. Mr. Chaudhary.
My humble submission is, now the earlier committee who filed the case, that committee stands superseded. Now the successor committee has no objection regarding
construction. Is be whatever. And they have now filed an IA for amendment, correct?
No, amendment has been allowed.
No, this IA that has been filed
No,
today.
implement.
No.
That is allowed already.
Yes.
Now they
have filed an implement. Amendment petition.
Correct.
Now, what is that amendment they want to make? Lots will kindly see that.
Yes. Mr. Datta, what is the amendment that
Amendment is about, my lord, with regard to the, my lord, locus of the committee, my lord. So the new committee which is supposed to have taken over, my lord, that committee is, my lord, is an institutionalized fraud, my lord. that committee has got
These are grounds which were available to you when you had
no, my
filed
lord.
your
No, because
petition?
this has been they have been implemented just now only, my lord.
They have been included as
True, my
a
lord.
party respondent.
Yes, my lord.
But what about their...
That's the reason, my lord.
they have come to office recently.
No,
My
they have
lord.
come to office, my lord, since the implement was pending, my lord. Now, since they have been implemented, now had the implement refused, my lord, the things
My
would be
lord,
different,
the
my lord.
general house of the school, not only in the GB meeting, in the general meeting of the house, they have superseded this committee because they were indulging in activities which were detrimental to the interest of the school.
No, man, not at all.
Now a new committee has come. New committee has no issue with the cat building coming up, my lord, over the plot of land. Who is this Mr. Mehdi, my lord? Who is he? What is his locus standi? No locus standi, my lord. How can he show
the government, my lord? What is the locus standi?
My lord, the land, my lord, the government. What is the wrong in this order, my lord?
Their document page page 86, my lord, their affidavit in opposition, my
Lordships
lord.
will kindly come to one order of the government which is under challenge in this proceeding. Then Lordships will take a call in the matter. Please come to, yes. 32, na?
My lord, since my learned
Page
friend is submitting,
32.
let him place his case, my lord. I will give my reply, my lord. I will not interject in the meanwhile.
Okay, no problem. Hey, here you go there. Hey, development order. Page 80. What is wrong in it, my lord? Let us see.
Page 80.
Yes. This is what has been impugned in the writ proceeding.
2322.
Page 80 in WPC number
Yes,
2956. 80, my lord.
80, Annexure P 2322.
No, my lord, it's
Annexure 15, my lord. Annexure 15, I guess. 15.
15.
Page
80.
80.
Oh,
In the
the writ
WPC.
petition.
Yes.
Yes. Got it. Annexure
Kindly
15.
see, this is the minutes of the subdivisional level land advisory committee. The meeting was presided over by so-and-so, Deputy Commissioner. The committee, after threadbare discussion, took the following decision in the meeting. A brief breakdown of the case is as follows. In the year 2011, a plot of land measuring 1 bigha covered by government DAG number 1852 of village Ulubari under Ulubari Moja was allotted to Central Administrative Tribunal for constructions of his office building. As per record, the said plot of land is bounded on north by DAG number so-and-so, south so-and-so, east by so-and-so. The west by DAG number so-and-so. Towards east was the school. At the time of construction of boundary wall, it was found that the plot of land is less than 1 bigha. The tribunal had approached the government to hand over the full area of the land. The tribunal also filed WPC number so-and-so before the Honorable High Court, and at the time of demarcation, it was found that 10 lakhs of land is used for public road. In the eastern side of the tribunal's land, by the side of Ramakrishna Mission Road, a plot of land was allotted to City Montessori Private in the year 1982, while later dated so-and-so, with the condition that land would revert back to the government in the Revenue and Disaster Management Department if it was not utilized within 2 years. The said plot of land falls under DAG number 78. As per report of the circle officer, Guwahati Revenue Circle, during the field verification of the school on a working day by the concerned Latmandal of Guwahati Revenue Circle, it transpired that the school is not functioning at all. The school rooms are in dilapidated condition without any roof and wall, whereas the backside of their plot of land, they have rented out the land to rickshawalas, etc. There are no records available to substantiate that the school is imparting education continuously since the time of allotment. The school is in a dilapidated condition. Many parts of the school are broken. The management has rented out a part of the plot of land without requisite authorization. Thus, for the purpose of allotting the land is defeated as per the conditions incorporated in the allotment letter dated so-and-so. And in view of the larger public interest and keeping in the stature of the tribunal, it is proposed to cancel the allotment at the Montessori School and reallot the land to Guwahati bench of the tribunal, which will facilitate the tribunal to construct a suitable court-cum office building catering to the needs of the central government civilian employees of northeastern states. In return, it is proposed to allot 4 kotha 10 lesas of land to City Montessori, which was earlier allotted to the tribunal from the government DAG number so-and-so, which is currently in possession of the tribunal. The school is already in a dilapidated condition and many parts of the building are broken condition. Therefore, no prejudice will be caused to the school in shifting their premises to the plot of land of that number so-and-so. Honorable MLA Guwahati East LAC and member SDLAC have suggested that a caveat, anyway, my lord, this was there. So, my lord, what is wrong in this decision, my lord?
This
End of the day, a larger public interest has to prevail.
Have please challenged this decision?
Yes, this is the decision which is under challenge.
In this
Yes.
One of the challenges.
Now, my lord, kindly see, when this decision was put to challenge, it was by a committee, which committee is no longer there. Now, the successor committee has no issue. They have accepted this revised land which has been given to them.
From where do you say that?
From the document, they have got respondent number 10 and 11. They got implemented.
Who is appearing for them?
My learned friend.
I filed an affidavit yesterday.
Yes.
You have no objection.
No objection.
And
Successor committee.
The members, the writ petition are members of the old committee.
Yeah, and they have been removed by a general house. That resolution
Where
and
do
all.
we get that from?
Yes. I'm showing it. In fact, they have filed affidavit, my lord. If your lordship will kindly come to that affidavit at page number 280.
In the writ petition?
Yes. No, my lord. Yes, in the WPC.
Affidavit?
Affidavit, it was filed yesterday. It was filed by one Dilip Das.
Even I have to reply to that also. It's filed yesterday.
Page 280, na? Correct?
280.
Page 280.
Yes. Kindly see, my lord. A general meeting was.
Yes.
A general meeting was held in the City Montessori School, Birubari, in presence of teachers and guardians of the school and the general public at 2 p.m. that today, that is 14/5/22. In the beginning, the president of today's general meeting elaborated the purpose of the meeting. General meeting unanimously selected Dilip Das to preside over the general meeting. The resolution adopted by the general meeting are as follows. All the members present in today's meeting strongly criticized and condemned the stand of the governing committee of the school and its principal and passed resolution deprecating them for their negligence leading to risking the students and their academic session. The governing committee is forced to explain for their negligence within 7 days. It has been unanimously decided to dissolve the school governing committee and elect a governing committee. The earlier committee is directed to hand over all the documents to the
This is a private school?
Private school. Earlier committee is directed to hand over all the documents to the newly reconstituted committee. In addition to respecting and obeying decision of the district administration, it is requested to the government that remaining official formalities procedures may be effected at the earliest. Today's meeting congratulated the newly reconstituted committee and decided to convene a meeting with the guardians and teachers in the next 1 week. Today's meeting directed newly constituted Porisalana committee to liaising with the government administration for completion of all necessary formalities.
Okay.
Kindly see, my lord, this is the new committee.
Yes.
Then my lords will kindly come to page number 285.
It was at your
Sorry.
instance that impediment was allowed?
Yes. 286, my lord. (286).
At the time, that minutes which you had relied, that time the members were different, and then this committee came, the second.
No, they were there earlier, prior to May 2022. They were there when they initially filed the writ petition.
And then, no, that minutes which the
Minutes came in May 22.
They were there.
No,
they were not.
Not there.
Thereafter they came.
No, they came. They were before to that.
And who were there at that time?
At the point of time when they moved the writ petition, the person who were represented in the writ petition, they were in the governing body.
So they again came back. And then
no, they haven't come back. They are ousted. They are no longer there. Now it's a new committee who has come up.
Mr. Chaudhary, that minutes which you said is under challenge in the writ proceedings, whereby this whole arrangement was done, correct? That when that was done, were they in the committee?
Yes, they were there.
And then that is how they filed the petition.
To that extent, we have no issue.
Yes, subsequently the committee, according to you, by this general meeting, they have been replaced.
They have been replaced.
During the pendency of the writ petition.
Because that was in March.
That is
and
how
this is
they
of May.
And after being implemented, you are saying that you do not have any.
Yes. Now, Milord will kindly come to page 286. Is very important.
Yes, I have it. Handing over, taking over.
In pursuance of the resolution of Subdivisional Land Advisory Committee meeting held on 19/5/22 at 11 a.m. in the conference hall of the office of the Deputy Commissioner, Kamrup Metropolitan District, land measuring 4 kotha 10 lesa covered by Dag number under Ulubari Moja has been allotted in favor of the principal City Montessori School.
Land measuring 0 bigha, I think.
0 bigha 4 kotha. That means not less than 1 bigha, about 10 lesa less. Allotted in favor of the principal City Montessori School for construction of the school building, and accordingly the possession of the said land is taken over to the principal City Montessori School on 23rd day of September.
This is in terms of that meeting,
yes,
which is under challenge.
Yes, my lord. Therefore, the new committee has accepted this new land. There is no dispute regarding that. Then, my lord will kindly come to next page, page 218, 287. Page 287.
When you say new committee, you are referring to them.
Yes.
So 23/9/22, and the general meeting date is?
General meeting was on, I think May, my lord. General meeting was on 14/5/22. Yes.
14/5/22. So after that they have taken.
Yes. It was in September. Now kindly come to page 287.
You want to challenge this?
Well, look, I have challenged this, Miller. And
okay. Now please come to 3. Discussion regarding no link of the newly reconstituted City Montessori High School Porichalona Committee with the earlier City Montessori School Committee. Then please come to the proceeding. Yes. An executive meeting of the City Montessori High School Porichalona Committee was held at 4 p.m. evening, the City Montessori School premises. In the meeting, it was deliberated that the City Montessori High School Porichalona Committee has got no relation with the old governing body of this City Montessori School and its secretary Khonin Mehdi, and following resolutions were passed. Now this is Khonin Mehdi is the person who represents the petitioner. First resolution. Sri Khonin Mehdi led earlier governing committee of the City Montessori School situated in Ramakrishna Mission Road was dissolved by general meeting on 14/5/22, and in presence of the general public, the governing committee of the City Montessori High School was reconstituted under the presidency of Sri Dilip Das. Therefore, newly reconstituted committee has got no link with the earlier dissolved committee of Khonin Mehdi. Second resolution, it has come to the knowledge that a legal dispute was going on between earlier City Montessori High School Governing Committee and Central Administrative Tribunal. Since earlier committee had become invalid and newly reconstituted committee is not aware of it, newly constituted committee, newly constituted City Montessori High School Porichalona Committee is not willing to continue with legal battle with the Central Administrative Tribunal. Therefore, it has been decided by City Montessori High School Porichalona Committee to withdraw all cases and the Central Administrative Tribunal pending before the court, and authorize President General Secretary to all formalities to withdraw the cases.
Who is the petitioner?
In the first case, my lord, it was one gentleman called Khonin Mehdi.
In his individual capacity?
No, the committee as a secretary of the committee. He was a petition number 2, the committee is there.
Yes. Now, my lord,
no, because you see, with the change...
My lord. No, well, I'll submit that. Change is not change, no change at all. It's by
no, you cannot say it is no change.
No, I'll show, my lord. Some 20 people, my lord, have hijacked, my lord.
Now, my lord, the issue before this honorable court is very simple. This school is a juristic person. Somebody represents the school. Now, the person who represented the school has no authority to represent the school any longer. And the successor committee
is that when this impleading application was filed by you, you have never objected.
Never objected. We filed objection, my lord. We filed
No, but
objection.
at the time of hearing,
No,
you said nothing.
No, my lord, it was allowed, my lord, because, my lord, that day, my lord, of course, I was not present, my lord. My learned colleague was there.
That you see, don't
My lord,
put
but then,
it
my
on
lord,
the
he, my lord,
court.
no, my lord,
No, but be that as it may, on that day, because
No, my lord, because
this
objection-
court had asked, there was
my
no
lord.
objection.
My lord, he was, my lord,
Now, you see, before I go into the merit,
my lord,
the question that is, you see, I'm expressing it so that I get
I
answers
understand.
from
I understand,
all
my lord.
of you.
I understand, my lord.
Now, City Montessori High School
my lord,
is undoubtedly a juristic person.
my lord,
Correct?
my lord.
And
somebody has to represent it.
Petitioner number 2 has filed it in a representative capacity,
My lord.
not in his individual
Sure,
capacity.
sure, absolutely,
This
my
much of facts is admitted.
Absolutely,
There's
my
no
lord.
dispute.
No dispute.
Now, keeping that in mind,
My lord.
it appears that there has been a change, rightly, wrongly,
My
a
lord.
change has been done.
My lord.
Until and unless you go before the appropriate forum and
Yes, get a declaration from the civil
No,
court.
I will
and
show
show
Mr. Datta.
Then you
One
come
second.
to here.
Until and unless that exercise
I will-
is done,
I will
one
show, my lord.
second, hear me out.
My lord.
Until and unless that is done,
My lord.
since they have already implemented themselves
My lord.
without objection from any side, and they have filed their affidavit bringing on record these changes, now they say they don't want to pursue.
My lord,
How
I will show,
this
my lord.
court will go on with the hearing of this writ petition
Precisely.
filed by the earlier members?
Exactly, my lord. The committee, my lord, I will show, my lord, the committee is not as per law, my lord. It could not have been formed. Because, my lord, the issue here is, my lord, it's not...
Mr. Datta, is that an issue before this court?
Also an issue, my lord, because
Okay, that is a private.
no, my lord, that is, no,
it
my
is
lord.
not a
No, my lord,
government
no,
school.
my lord, the act is there, my lord. The act is very much there.
Be that whatever,
My lord,
but
the act says, my lord,
Mr.
it has to be, my lord,
Mr.
committee.
Datta,
My lord.
whatever your
My
grievance
lord.
about the formation of that committee
My
is
lord.
concerned, this court is very clear in its mind that that has to be challenged before any other forum, but not before Article 226.
It can be.
Right? Yes.
My lord, my submission it can be, my lord, because there is an act, my lord, for this committee. This committee couldn't have come out of the blue, my lord. My lord, the act is very clear, my lord. The act, my lord, is called, my lord, the
Can you
non-governmental...
file another writ petition?
No, my lord, I'll come to that, my lord.
You see,
See, my
Mr.
lord,
Mr.
once-
Datta,
my lord.
you cannot be challenging that by this. In that case, this court is going. If that is the
My
amendment
lord.
that you are seeking,
My lord.
straight away I'm going to reject that amendment because in that you may have a cause of action.
My lord.
This court is not denying
My-
you the cause of
my-
action.
Then, my lord, reject it, my lord. That's a different
You-
issue.
you
If
may
my lord
file
want to
a
reject, that's a
petition.
different issue, my lord. But the issue here is, my lord, this committee, my lord, if this is allowed, my lord, a fraudulent committee will be, my lord, allowed to, my lord, take over the land, my lord.
You see, Mr. Datta, I am not going to allow.
My lord.
I am not allowing or disallowing anything.
My lord.
I am merely putting a legal question before you go.
My lord, my lord.
That in the facts that has come before this court,
My lord.
as regards the formation of the new committee,
My lord.
can this court proceed with the writ petition which has been filed by
My
the
lord. My
earlier
lord.
members
My
and
lord.
representative capacity when the new member on affidavit is saying that they are not interested?
My lordship is-
Because ultimately you have not come on an individual. You may withdraw this, file a petition tomorrow challenging everything. That's a different thing.
My lord.
You understand what I am
I
saying, Mr.
understand,
Datta?
lordship. My lord, here the question here is, my lord, this body, my lord, let's say it's a company, my lord. That's a company. Can, my lord, anybody come and say that I'm the managing committee of the company, my lord? I cannot say, my lord. There is a procedure. Here, what has happened, my
Then
lord?
why did you allow the impediment?
The impediment, we had to file the objection of that, my lord. That
Objection
day, my
was
lord,
not placed
that day,
before
my lord,
this
no
court.
hearing took place, my lord.
You were being represented.
My lord,
Were
my
you
lord.
being represented
No, my
or
lord,
was it an
my-
ex parte
the-
order?
No, the only submission that my learned friend had made, my lord, that I am appearing for so and so, the order was passed, my lord.
No,
That's on record, my lord.
They did not give any
No,
objection.
no, that was not even allowed to. That could not be raised, my lord, in 1 minute time. It could not be raised, my lord. My lord, that's very much
That
there, my lord.
cannot be.
It's there, my lord. My lord, he only said, my learned friend only said that I am appearing for
You
so and
see,
so, and the
Mr.
order was
Datta,
passed, my lord.
The
Allowed, my
person
lord.
who had appeared on the other day
My lord.
ought to have raised his voice and said he has an objection. Obviously,
My lord, he raised, my lord.
Obviously,
He raised,
if
my
he would
lord.
have said he has
He
an
raised, my
objection,
lord.
this court would have asked,
Well, he
what
raised,
is
my
the
lord.
objection?
He raised, my
I
lord.
don't remember anything
Well,
like
he
that has
raised, my lord.
happened.
He raised, my lord.
And if you have any grievance to that, then you
My lord.
file a review in that. But
then
where is that order of impleadment? Is it available in the IA that you have filed today?
Yes.
Mr. Datta, the IA that you are filing today, have you annexed?
IA, my lord.
Have you annexed that? Is it
No,
there?
my lord, I have not annexed that, my lord.
Which is that IA then?
That I have not annexed. But this IA today that I filed, my lord.
Do you have a copy? Just give me a copy. Just give it for a second.
In fact, my lord, when the initial implementation order was passed, there was a mistake, my lord.
And then it was corrected.
That was corrected. The name was corrected.
Names were corrected. Or that operating
That
part.
operating part was mistake, my lord.
And who was the counsel who had appeared?
There was one Mahanto, Mahanto, my lord, J. Mahanto. He's a colleague of mine, my lord. But my lord, since I was on legs, my lord, I had asked him to, my lord, take time, my lord, for appearing in the take time, my lord. He, my lord, a new boy, my lord, so he, my lord, took time in saying, my lord, he said that I have an objection, my lord. That was the only thing he could say, my lord. That's the difficulty, my lord. Otherwise, my lord, this period, my lord, we had filed a detailed objection.
But then address the legal issue first.
Well, I'll address the legal issue, but because unless this implementation is allowed, my lord.
Rightly, wrongly,
my lord.
Since this body has come,
my lord,
you are entitled to challenge the formation of the body. That's a different thing.
Therefore, my lord, I have filed this, my lord, amendment application, my lord. Let this be taken on record, my lord.
Mr. Datta, that application, this court is not inclined.
If a lordship refuses that,
no, because
rejects, that's a different issue.
But that is why I'm saying you first address the legal issue.
My lord.
You see, the question that the answers that I'm looking for is whether, in view of the change, you can still proceed with this.
That's the reason I'm saying, my lord.
So that
Lordship will see the committee, my lord. 21 people got together, my lord.
Then you're again going back to the merit of the formation.
Because the formation
without taking, let us accept for a moment that this committee has come.
My lord.
Do you still have the right to proceed with this writ petition?
My lord, that's the reason.
Show me that.
That's the reason, my lord, how the committee can be formed. That is important, my lord.
I'm not getting into that issue right now.
What I'm saying, my lord,
because to get into that issue is to get into the merit of the formation. That issue is not today before this court.
The difficulty, my lord, is that
and by way of an amendment,
my lord,
because that's a different cause of action, entirely a different cause of action.
The difficulty here is,
because what you are seeking here is the challenge of the minutes, right? And now in the meantime, the committee has changed. Now the amendments that you are proposing, where are they? In which paragraph?
My lord, paragraph 8, my lord, I have given the pleadings that I want to incorporate, my lord.
Paragraph 8?
Paragraph 8, the pleadings I am to incorporate. And my lord, paragraph...
Yes, you are saying is that he still continues.
Yes, my lord.
Now on what basis are you saying he still continues?
I will show that, my lord.
That is what I want.
I will show that, my lord.
You show me legal position. How legally you can say
that is what
after
I'm saying,
this
my lord.
committee has come?
That is why I'm saying, my lord. Lordship will kindly take into account, my lord, this act, my lord. How the committee is to be formed, my lord.
Yes. Which is this act?
Assam Non-Government, my lord, Institution Regulation and Management Act, my lord. This is for the institutions, my lord, which are not, my lord, under the government, my lord. Page 573, my lord, of this book, my lord.
Education manual.
Education manual.
The book is not here.
I have, my lord, well, I have the gadget notification, my lord. I can.
The practice of giving prior book list seems have gone away with time. By way of an amendment, you are going to change the entire tenor of the writ petition?
No.
Can that be allowed,
No,
Mr. Datta?
I am not changing, my lord. What I am submitting, my lord, is that I exist to.
What is your relief in the writ petition?
Relief in the writ petition are manifold, my lord. In fact, I won the entire, because the entire way this land has been taken, my lord.
What are the reliefs?
Reliefs, my lord, I have challenged, my lord, the decisions, my lord, to hand over the land, my lord. I have challenged, my lord, the cabinet decision also, my lord, by which the land is handed over, my lord.
That's what I'm saying.
In fact, my lord, the land was handed over even before the cabinet resolution took place. I will show, my lord, how this fraudulently the entire thing has been done. My lord, I had filed an FIR against this committee, my lord. The FIR is not being registered because the higher ups are there, my lord. The FIR has not been registered, my lord. That also I brought on record. The committee, my lord, the original committee, my lord, came up with a, my lord, paper notification that this committee has got nothing to do.
By this amendment now you want to add another relief and taking over certificate
of the school, my lord.
Correct.
Very same land, my lord. It's a part of the same transaction, my lord. It's part of the same transaction, my lord. Because this land, my lord, Lordship will see how the committee, my lord, who has to be there in the committee. There are no members of the committee, my lord.
Which provision?
.573 it starts, my lord.
573
Act, my lord.
Page.
My lord, page 573. Yes, my lord. This is called the Assam Non-Government Education Institution Regulations and Management Act 2006, my lord. Whereas it is expedient to regulate the establishment and management of non-government education institutions in the state of Assam and for matters connected and incidental thereto. Now, Lordship will kindly turn to, my lord, page, my lord, 581. The Constitution of the Administrative Recognition, not Constitution Recognition Committee, my lord.
Go slow, Mr. Datta.
Sorry, my lord, sorry.
You take your time, no problem.
587, 587. Managing Committee, 12. Section 12.
Yes. Constitution of Managing
Committee, my lord. Every non-government education institution shall constitute the Managing Committee, constitute the following, namely, the chairman or the president, or the principal managing agent of the society or trust or the association of individuals, or the persons or individual establishing the non-governmental education institutions shall be the chairman of the Managing Committee. Headmaster, principal of the institution, as the case may be, the headmaster is not a party in this new Managing Committee.
No, Mr. Datta, I am not disputing this fact.
My lord.
You see, I am not even going into whether this has been correctly done. For a moment, I am assuming that this has not been correctly done. But you see, this exercise has been done. Now, this needs to be challenged, and you need to get an order. What I am saying is that this is not that forum, right?
But difficulties, my lord.
This is what be with the court for a minute.
I understand.
Because you see, I am only sharing my views because at the end of the day, I have to author an order, right?
I understand.
Now, I am trying to tell you so that, if you have something, you can assist me. Only for that purpose. So don't get agitated.
No, nothing to get agitated, my lord. Only thing that I am submitting, my lord, is
this committee, my lord. Now, suppose that is the situation,
my lord,
then I reiterate what I have been saying.
My lord.
They have come.
My lord. But the issue here...
Now, whether in that situation, admitting that this has been done rightly, wrongly, without going into that,
my lord,
can you continue with the proceeding in the representative capacity of a school of whose managing committee is now by respondent number 3 and 4.
Now, my submission will be, my lord.
10.
My submission will be, my lord. I have an opportunity perhaps to separate separately. Challenge it separately, my lord. That is another aspect of matter. But here, Lordship will consider one aspect of matter. If this writ petition is allowed to be withdrawn, my lord, by this committee, my lord, the entire writ petition becomes infructuous. Now, this committee, my lord, therefore I am submitting, my lord. This committee, my lord,
writ petition may become infructuous, but you will still have a right if you have a right, if you have a cause.
No, my lord.
You can carry on.
No, my lord. Then the issue will be different, my lord.
Because you see, representative capacity is now, it is there.
No, my lord. See, Lordship will see the problem here, my lord. Now, even if I let's first, for example, challenge with this committee, my lord. Let me say, my lord, I challenge this committee, my lord. That issue will need, my lord, years to be decided, my lord. By that time, my lord, the entire matter will become infructuous, my lord. The difficulty here is, my lord, I am coming to that, my lord. The committee, my lord, there is a procedure of forming in the committee, my lord. Well, it cannot be anybody coming in the place, my lord, and say that I am the committee, my lord. Tomorrow, someone cannot say, my lord, that no, it's not like a coup, my lord, that I remove.
Are you carrying any decision for amendment?
Well, I have not carried, my lord. Since I filed it, my lord, I did not carry any decision today, my
Mr. Chaudhary, do you have any decision on amendment? Because
No, my lord.
By way of
no.
amendment, if I recollect, by way of
amendment, my lord, the basic principle is till before a judgment is delivered, also an amendment can be permitted.
But by way of amendment, it cannot change the
alter the
color.
basic structure of the case.
Correct.
Now, my lord,
Correct.
if my learned friend would bear with me for 2 minutes, my lord, now they are also put to challenge the subsequent resolution. Now, how your lordships will go into that?
No, you see, this court is having
my
same
humble,
issues.
my humble submission is, my lord,
are
they
you
are not
having any decision on that?
on amendment? No, my lord, today I am not readily available, but then, my lord, these are all subtle principles. It cannot alter the basic structure of the case. And secondly, if you are agreed by the resolution of this...
I'm posting this matter tomorrow.
Well, can be Friday, well.
Tomorrow. Friday is difficult. It's the last working day. Tomorrow.
Yes.
Because this court is also conscious of the fact that administrative tribunal building is waiting. So if suppose unnecessarily, I don't think we should keep things pending. We will see.
As far as I know, my lord, the inauguration is still away, my lord, because the building is not yet completed. Even colouring has not been completed. Glasses are, I think, being put, my lord, that I have to my instructions. So, my lord, it's not as if, my lord, that tomorrow is going to be.
See, look at tomorrow.
But that's up to your lordship.
Right now, the issue first that arises whether the amendment will be allowed or not allowed.
Yes.
If this court comes to a finding after hearing you both tomorrow again that the court is allowing the amendment, then of course this court will have to grant time to the petitioner to do the needful.
Yes.
Alright? However, if this court comes tomorrow to the finding that the amendment sought is not required to be allowed, this court is going to reject that IA. In that situation, will this court be able to carry on with the hearing?
Exactly. That's the issue.
Now that is the legal issue. So both of you come prepared for the second issue also. Because otherwise again the hearing will get prolonged. Because suppose you show me that you have a right, we will proceed. And however, if from the other side you show me something that the right ends here because the person representing that body is no longer there. So therefore, how can that writ petition...
The body is there, but the person who represented them is...
Correct. But you see, body has to be represented by someone.
Yes.
It cannot be represented by a person who is no longer in that office.
I was also thinking in another line. Normally, your lordships will issue a writ of certiorari in a case where there will be a failure of justice. Is it a case where any failure of justice would be occasioned?
Those are on merit. Those are on merit. I am not on merit. As of now, before we enter into the merit, let us first also examine this preliminary
question
issue.
Is therefore the issue is whether any live issue is to be decided.
Correct.
In view of the
in a petition,
change of the stand of the body.
Correct. After taking note of the affidavit that the new
person live issue survives,
because the new members have taken a clear stand.
They
have
want to
already
withdraw
taken
the case.
Because they've taken over the 4 Katha land which has been given.
Yes.
So they have admitted the fact.
Yes.
After that, there is no live issue.
Precisely.
No, that's what I am saying. If we take cognizance of your affidavit, there is no live issue to be agitated. So I think that basic legal question has to be first. You see, Mr. Datta, as regards the formation and all, that will be always open for you.
No, but then
you can come by way of a subsequent writ petition, or you can go before any other court and take an injunction.
I understand.
That is for you
what happens
to decide.
What happens to this writ petition? That's because that is the issue. Because
This is why I put the question very firmly before both of you, that whether any life issue still continues after the new members have come.
Tomorrow we'll make the submissions.
That is the issue, Mr. Chaudhary. Anything else?
Tomorrow actually I am contesting in the election. Oh. It will be day after tomorrow.
Tomorrow is Thursday. Okay, Thursday.
That is the reason I paid for day after tomorrow.
No, actually my learned friend is assisting Mr.
Chaudhary. You are at the other side there? All right. Hearing remains inconclusive. List this matter again on Thursday.
Deep